Joining us. It's good to see we have our technology working today. I have no window cleaners booked, so we should be good. As participants today were involved in the previous session yesterday, I'll not revisit the housekeeping or the general introductory remarks I made at the start of the inquiry. This session is going to focus upon the planning and energy policy context for the proposed development. Participants have already been supplied with an agenda to help steer the discussion. For the benefit of those following along online, my name's Stuart West. I've been appointed by Scottish ministers to consider the application for the renewable energy development at Hollandmey and to present a report to Scottish ministers with my recommendations following this inquiry. Before we get underway, I'll just ask parties to introduce themselves, members of the team that will be participating this morning, and we'll start with the applicant.
Yes, good morning, sir. My name is Colin Innes, and I'm a partner in the law firm of Shepherd Wedderburn. I'm instructed by Mr. Steen from Scottish Power Renewables legal team. In terms of this session, I have a background in planning matters, and I'm a legal associate to the Royal Town Planning Institute, also accredited by the Law Society of Scotland as a planning specialist. I've practiced in the planning field for 30 years, with a particular emphasis on energy-related matters. I've also sat on various industry bodies for Renewables UK, Scottish Renewables, and also in various working groups on behalf of the Scottish Government in relation to renewables matters. I'm now going to ask my planning witness, Mrs. Lisa Russell, to introduce herself.
Good morning. Yes, I'm Lisa Russell. I'm the Planning and EIA Director at Stevenson Halliday, and I'm the lead planning consultant for the applicant relating to this site.
Council.
Well, sir, I can't tell you how glad I am to be able to talk to you shortly after 10 o'clock this morning, unlike yesterday morning. So my name is James Finlay, King's Counsel, the Scottish and English and Welsh bars. So I have two witnesses this morning, Claire Farmer-McEwen, who you heard from in part yesterday, and Peter Whelan. And just to confirm that Mr. Whelan's CV had been omitted in error, but hopefully a copy was supplied to you yesterday and to the applicants. Thank you, yes, sir.
We did. We received that yesterday. Thank you.
Apologies for that coming in late.
So this hearing is going to take the form of a structured discussion in the same manner as yesterday, where we'll work through the items on the agenda. For each item, I'll initially ask one party for their thoughts before moving on to seek any counter views from or additional information from the other side. Before we commence, can I just check that there are no questions again regarding the procedure? No questions. So the first item on this agenda relates to renewable energy policy framework. A comprehensive overview of the relevant national and international aims, objectives and policies was provided with the hearing statements and within the wider evidence submitted in relation to the application. With the exception of the upcoming agenda items, I am satisfied I have all of the relevant documentation to fully consider this area as set out within the agenda. But I would like to give parties an opportunity to just comment on any of the matters raised by others within their hearing statements that don't relate to an item that's on the agenda later on. So I'll just start with the applicant on that. Do you have any comments on the matters raised by the council?
Yes, thank you. I think following the hearing session yesterday, it's probably quite useful, I think, to set out the difference in opinion, and I think that's really what I'll kind of focus on really at the moment. There has been a few points that I'll go through, but referring particularly to CD reference 1202, which is the Council's hearing statement. And I think that there is a fundamental difference really in opinion in terms of what the new renewable energy policy framework means and the changes that have been brought about regarding that. I think it introduces a significant step change and a fundamental way in which we look at assessing policies, particularly with the onshore wind policy statement. I'll come to some of the onshore wind policy statement subsequently, but I think in turning to the Council's hearing statement, I think just picking out some of those differences, it's really where I believe that they're perhaps not grasping that change and a feeling that it is the status quo. It's as policy was before MPF4 and OWPS was introduced. I think that's emphasised in paragraph 4.2 at the end, which explains that it was a very clear theme of SPP, and again in paragraph 4.3, which talks that the spatial strategy reflects existing legislation, and again in paragraph 4.4, which says it considers that the strategy for Highland aims to protect environmental assets as well as to stimulate investment in natural and engineered solutions to climate change, which is on page 26 of that document. This aim, which may clearly require a balancing exercise, is not new and is reflected through the document. Also then within paragraph 4.9, it says the policy goes on to state that significant weight will be placed on the contribution of the proposal to renewable energy generation targets and greenhouse gas emission reduction targets similar to the previous Scottish planning policy. And again, in paragraph 4.11, it talks about policy 4, which we'll discuss later on, but it explains that it first sets out that development proposals by virtue of type, location or scale that will have an unacceptable impact on the natural environment will not be supported. And again, they reiterate this point. This again reflects existing policy. And finally, in their summary, that the policy framework which formally implements the way in which decisions were already made, that's a presumption in favour of sustainable development. I think that just emphasises the point throughout, and it reflects the decision-making process and the reasons for refusal in the Council's consultation response. But however, we consider that there has been a very significant shift, and that is best summarised predominantly by the onshore wind policy statement, and referring to CD5(9), which paragraphs 3.61 and 3.62 are most relevant. At 3.61, it states that meeting our climate targets will require a rapid transformation across all of our sectors of economy and society. This means ensuring that the right development happens in the right place, that meeting the ambition of a minimum installed capacity of 20 gigawatts of onshore wind by 2030 will require taller and more efficient turbines. And then the document goes on to underline the last point, that this will change the landscape. And recognising that it is not necessarily the status quo, it's a recognition of a new change in direction to meet those requirements. And then again in 3.62, it advises, we led a revised national draft planning policy for in the Scottish Parliament on the 8th of November, signalling support for all forms of renewable, low carbon and zero emission technologies, making clear that the LDP should seek to realise there is full potential for electricity and heat from renewable, low carbon and zero emissions. But it also goes on to confirm that the only areas where wind is not supported are national parks and national scenic areas. Outside of these areas, the criteria for assessing proposals have been updated, including stronger weight being afforded to the contribution to the development of the climate emergency, as well as community benefits. And I think it is these statements that really demonstrate it is not the status quo. There is stronger weight. It is changing. It's an understanding that there will be a change to the landscape, and that we can't have the same policies that were in place prior to MPF4 and the OWPS. We will not meet the targets. We were failing to meet the targets, and there is a step change to meet what is a challenge. I think is recognised in the evidence that's already within the hearing statement that was provided to you. So I think that sets out really the kind of fundamental differences in opinion, I believe, between ourselves and where the Council took the Council's position. Thank you.
Thank you. So before we move on to the items in the agenda there, I will just move across to the Council and see if there's anything that you'd like to raise in particular. We have got items on the agenda where we can look at the balancing of the competing the benefits versus identified disbenefits and whatnot. But if there's anything in particular that you'd like to raise in those statements, I'd welcome it now.
No, but can I just respond to the statement that's being made, because it overstates the position. The and paints the council into a picture that it hasn't adopted. There is clearly a continuity between SPP and MPF4. Council accepts that the need case has been ratcheted up, to use the expression of the reporter in Kirk Wind Farm, whose conclusions were accepted by Scottish ministers. But the use of the word step change has been promoted by applicants for as long as I've been doing wind farm inquiries. With every new policy statement, one has to be careful and not to exaggerate the extent to which there's a change. There is still a balancing exercise to be struck between what's acceptable and what's unacceptable. That balancing exercise has been influenced, as I've just accepted, by the new policy approach and the new overall framework. But I refute the suggestions that have been made that the council has failed to recognise the changes in the new policy position.
Okay, thank you. I think that to get matters moving, I understand there's a difference of agreement there. I don't want this to turn into a debate on whether or not the council has done. I'll have the two different things before me, and I can make my own, draw my own conclusions on whether or not I think things align. We'll just go back briefly to Mr. Innes there, who wants to make a comment. But I don't want it to be an argument between parties on this one.
I fully appreciate that, so there's a lot of material, and indeed we've got a statement of agreed matters which reflects a lot of the material before you. I've got one further matter I just want to clarify, and that arises from paragraph 8.29 of the report on handling, which is CD 002 014. And it's a statement, and again, it's discussing this context of the onshore wind policy statement and the need for further renewable capacity. And at the end, the last sentence says, and what it says is, with regard to planning policy, these statements largely reflect the existing position outlined in MPF3 and SPP, a policy framework that supports development and justified locations. And it goes on to say, in addition, it must be recognised that the greenhouse gas reduction targets and the targets in energy strategy are related not just to the production of green energy, but also related to decarbonisation of heat and transportation. And I just want to raise one matter there, because I think it's an important one of principle. If one goes back to the white paper, which is the UK government's energy policy CD 05.40, one sees the challenge of how we can meet carbon emissions and how effectively we are driving carbon out of electricity production, and how we transfer that driving out of carbon into heat and transportation. And the key conclusion of that policy is that renewable electricity is the key driver to both reducing further greenhouse gas emissions that are produced by the production of energy, but also have this critical role in reducing the carbon produced by heat and transportation. And that is why within that document, the predictions about the demand and need for electricity are dramatic and overwhelming, because simply put, there is not other technologies coming forward that are capable of meeting that challenge at scale. So I think it is important to understand that when we're looking at renewable electricity, that it's not just driving out the carbon from existing energy production, it is also transforming into taking the carbon out of heat and also transportation. And I think that's an important point of principle, because it's partly driving the scale of ambition that we've seen produced by the Scottish Government in the onshore wind policy statement and the target date for the reduction of what's needed by WIN, because it is taking the into practice, as it were. And I think that's an important point. So don't know if the council are trying to draw a distinction between energy, decarbonising of energy through electricity and the decarbonisation of heat and transportation through electricity. But if they are, I don't think it's supported by policy.
Okay, I've taken that point down. I will give council opportunity to respond if they would like to.
Well, I think Mr. Ennis has picked on one phrase in a rather over-lengthy report to allow him to make a submission. I don't, certainly our initial response, and we can think of it for closing submissions, is there's nothing we wish to change in there, but I don't believe we're, or can be suggested, we're making a significant point of principle at all. It's more a statement of recognition of what's in the policy, but I think I'll leave it at that. I note that it doesn't appear that Mr. Ennis is taking exception with anything in our hearing statement, and that may put it in its importance in perspective.
And thank you very much for that. So with that said, we'll now sequentially work our way through the bullet points in items 3 and 4. If you have the agenda there before you. For item 3, I'm going to suggest that the applicant offers their view on the subject first, followed by the council, and then conversely, I'll ask the council for their views initially for the items listed in item 4, before moving back to the applicant. Does that make sense? I think it's the most appropriate way to go. So we'll move and we'll look at the first bullet point in item 3, and as I've said, we'll ask the applicant to give their view first, and then we'll go across to the council. So this bullet point looks at policy 1, which is tackling the climate and nature crisis.
Thank you. I think it may be helpful. I have a little bit to say actually about this policy, because I think it really goes to the heart of what the applicant is providing on site. I wonder if it might be helpful perhaps first just to talk a little bit about what the policy says and what it means in some of the context of that, to allow the council to come back so we can kind of agree that principle before we go on to how we believe the applicant is tackling each element of the climate crisis and the nature crisis.
Yeah, I'm happy to do that. Yeah.
I think that may assist. So I think the title of it says quite a lot, tackling the climate and nature crisis, and I think that it's important to note that this is relevant to all developers, all decision makers, and all development proposals. And I think the critical purpose of this is to send out that critical message to all developers and decision makers that it needs them to bring innovation and change and boldness, really, in addressing and securing solutions for both the climate and nature crisis, which are quite often intrinsically linked. And what does tackling the climate and nature crisis mean? Well, I think tackling in itself means it needs to be actioned. We need to understand it as a policy, what it requires, and the significant weight that it will be afforded, and also that it needs to be understood in context. How does this policy fit with other climate and renewable energy policy? And I think we need to draw quite a bit from the onshore wind policy statement, which we've referred to before, which is CD59, which we consider is the most important to help understand really and inform that response to the policy in terms of tackling the climate, because it sets out the targets for which we understand need to be met. So we consider that the OWPS provides the context for this policy and the role of that target. And it's clear, I think, that NPF4 and the OWPS, the onshore wind policy statement, were drafted at the same time. There's a lot of symbiotic and synergy between the requirements of both of them and the themes that are being applied throughout. And I think it is important just to refer to the onshore wind policy statement, page 4, paragraph 4, which states that while imperative, and that's meaning the 20 gigawatt of onshore wind target to meet our net zero targets, it's also vital that this ambition is delivered in a way that's fully aligned with and continues to enhance our rich natural heritage and native flora and fauna, and supports our actions to address the nature and climate crisis. basically now we've got the onshore wind policy statement and NPF4, which are now policy and not guidance. I think before there was a lot of encouragement to address both of these things, but it's now policy. I think it's important just to emphasise that point. And in support of NPF4, the onshore wind policy statement provides energy policy, which is not development management guidance. It's not a fail or pass test, but it shows the direction of travel that all developers need to take into account to meet the challenge and the change needed to get there. It recognises the kind of co-location and how best the proposed developments can make sure that the developments fit with the wider energy system and the ecosystems that are there. So I think that explains a little bit just about the context of it and what we consider that the policy actually means. But as I mentioned at the start, I think it's probably helpful kind of stop there before we go on to how we believe the applicant is addressing that.
Yeah, I have MPF4 open in front of me, obviously, so that we can refer back, and policy itself, it's not as in depth as the explanation you've just given there, obviously, but I think the main thing to go to the council with is to see if there's a general agreement that the onshore wind policy statement sets the context, and we should be taking these cues from there, and just a general your own thoughts on that and what's been said would be appreciated.
I'll ask Mr. Whelan to deal with this.
Yeah, good morning, Mr. Reporter. A lot's been said against one policy, and if you read NPF4, it's quite explicit in terms of what it states. The policy requires significant weight to be given to the global climate and nature crisis in considering this proposal. It's the opening policy of NPF4. And then the detail is then carried through on policy 11, which is pertinent to this application. If you want to look at the Kirkin supplementary report and the decision, I think it was circulated to you this morning, so I don't think it's contained in the CD documents, but we did email it through. And if you go to paragraph 40, you'll just see how other reporters have picked up on policy 1 and what they've said in their report. It's 2 lines.
I've not signed of that yet, but I'm sure if it comes through in the closing submissions and it's referred to in there, that'll be useful, and it will find its way to me after today's session for me to refer to, and if it gets added to the core documents, that'll be useful. And in terms of the onshore wind policy statement, do you agree that the context for policy 1 is set there, and it helps in the interpretation and application of that policy?
In part, yeah. In part, yes. In part, yeah. And also, just to make clear, NPF4 is a material consideration in this case. The development plan doesn't have primacy in the Section 36 applications.
So if we go back to Mr. Innes'
I want to make clear what documents are before us this morning, because in terms of the core documents that I have, document 8.3 is the report dated 9th March 2023, which is the subsequent report, which essentially, this is a Section 36 case where the reporter produced an original report, I think it was August 2022, and there was a subsequent report on 9th March 2023. Because effectively what the reporters were invited to do at that stage of the process was to have regard to the onshore wind policy statement and MPF4, and essentially come back and they often invited parties to comment, and they produced 2 reports. And as you'll see throughout the things, as far as I was concerned, the report that had been produced already was the 9th March 2023 report, and eventually the council have also today lodged the original report from August 2022. So I just see clarity so there's no confusion in relation to material that's lodged. Because I say, it appears the council have just lodged the report from 2022 and called it 8.3, and I have that as the updated report dated 9th March. So just to make sure that we're not working at cross purposes here, as I say, that's the basis of the material that I've had to work off, and we've had to work off. So I just think we need to clarify, otherwise we could be referring to documents and, as I say, becoming confused. Because as I say, the ambiguity is possibly that in CD 8.003, it is just described in the CD list as Kirken Wind Farm PLI report. And of course, there's actually been two. But as I say, as I understand it, it was the updated version that had been lodged before you, or the more recent of the reports.
Well, can I mean, it certainly need to iron this one out. Certainly on my, what I have at 8.3 is the original PLI report, not the updated one. If Mr. Ennis has the updated one, then he's in a better position than me. It's important, whatever the position is, and it's important because it is, I think, the only minister's decision on a Highland case post MPF4 that you have both reports, because it's impossible to read them without having both in mind, and the minister's decision without having both in mind, because they cross-refer one to the other. What we meant to supply to Mr. Innes this morning was the supplementary report.
That is the report that's on the core documents library. I've just clicked through there, and CD 008003 is the 29th, is the 9th of March 2023 supplementary report of inquiry.
Well, then that is slightly mystifying us, but then if that's the position, then we know that 8.3 is the supplementary report, and we will forward, insofar as we haven't forwarded already, the original report. But so certainly for my notes now, I'll call the supplementary report 8.3, and the paragraph that was just referred to by Mr. William was paragraph 40 in that. I should make it clear that the policy one is part of the background of policy one is clearly set by the AWPS, but by a large number of other things as well. And policy one deals with the nature crisis as well. It's a broad opening statement policy. And I'm grateful for Mr. Innes raising the issue of the Kirken report. We can deal with that in course.
Okay, that'll be useful. No, I've got the reference that's made there in the paragraph 40, and that'll form part of my consideration, along with all other things that have been brought to my attention. I think we'll go back to the applicant, to Mrs. Russell, to continue with your interpretation of policy one, if that's okay.
Thank you. I mean, I do believe it is important. You know, each policy has a purpose. It's not just an opening statement. That's what the foreword is there for. And it is important that it is given significant weight. So we need to kind of look at how the proposal is assessed in accordance with tackling the climate crisis and the nature crisis. And for that purpose, I think it's important just to stress that the applicants have provided a very kind of bold response to that. They're seeking to provide a low carbon energy system, and it's not just providing onshore wind, that's providing solar and battery, and looking at the benefits really of co-location. There's quite a bit within the hearing statement already, and paragraph 62 and 63 of the NPF4 updated planning statement, which is CD1-199. I don't really intend to kind of repeat all of that, but I think the summary is just the benefits in terms of generating enough wind to power 37,209 homes annually from the onshore wind, and that's then obviously supplemented by the solar and more security of supply, really, in terms of the battery that's provided with that. And that's been done with the aim of limiting the effects of the development through what we believe is kind of careful design and mitigation. The co-location of those other forms of technology can look to make the best use of the connection, which makes the system more effective and more efficient and adds diversity to the system. And in that respect, that we kind of note that the OWPS, which we do believe provides the context, confirms that the targets are not caps but minimum, and so we do need to look at maximising the effects to tackle the climate crisis to meet that set challenge by 2030. And for that reason, we consider that in terms of the tackling the climate crisis element, that the proposed development does make a meaningful contribution to doing so. I think the applicant has also really positively embraced the other requirement of Policy 1 to tackle the nature crisis. And that I think there's a big recognition within the OWPS, which we do again believe provides context, but it provides that for the nature crisis as well as the climate crisis, that developers can make a real difference, which is outlined in paragraph 3.3.6, and which states that the continued deployment of onshore wind and the restoration of peatlands and carbon-rich soil will both play vital roles in delivering Scotland's emission reductions targets, as stated in the Climate Change Emissions Reduction Targets Scotland Act 2019. It is imperative that we strike the right balance in how we care for and use our land, and given the established need for additional onshore wind turbines to tackle climate change and to ensure long-term availability of cheap renewable energy, in some cases, it may be necessary to construct on areas of peak. Paragraph 3.39 of the OWPS also confirms that the Scottish Government is expecting the sector to step up to the challenge of biodiversity loss, showcasing the considered schemes and that they won't just mitigate. I think that's the clear message that's coming across, and that kind of ties in Policy 3 and biodiversity, which is not discussed today, but I think, again, it's the OWPS and Policy 3 that help inform whether it does tackle the nature crisis. In 3.3.8 of the OWPS, it also said, it notes the remarkable advances in mitigation and restoration that the onshore wind sector has delivered over the last decade. The applicant has been at the forefront of that in blanket bog restoration, and these are measures that I'm just going to come on to talk about. So I believe that, again, strong support from Policy 3, which weighs in favour when you also consider that in light of Policy 1. Historically, I think when there were designations like the Phillips Main Mare site, the SSSI that's adjoining the development, a lot of people would have put a boundary around that and said, it's not for develop nearby, and it needs to be very restrictive. But the bold approach that the developer has taken here is to look to leverage their investment really in the area to secure, to manage and secure positive indirect effects on the SSSI and to manage the wider biodiversity of the site. And the potential habitat management plan that's provided relative to the impacts of the development is huge. And I would refer the reporter really to paragraphs 192 to 201 of my hearing statement. They confirmed that the applicant will restore 168 hectares of forestry to blanket bog, which is a considerable net gain over the predicted loss of 10.05 of this habitat. And the benefits of that are heightened on two counts. One is the applicant's experience and their recognition of being at the forefront of that blanket bog restoration. They have the knowledge and experience to deliver this habitat management plan using best practice. And there's also that direct link. So it's not just a habitat management proposal isolated, it's looking at an already recognised and designated area and looking to make indirect benefits of that. I think if undertaken successfully, which I believe is the kind of key message here, adjoining SSSI is 59 hectares, and what is being proposed is almost double the size of that again next door. And if undertaken successfully, you could end up with a habitat that is triple the size of that which is current. So in summary, I think it's important just to say that applicants haven't really just retrofitted the requirements. They were already really at the forefront of this type of development and securing these benefits. But it goes to the heart of this policy one. They are looking to tackle not only the climate crisis, but the nature crisis in the combination and how they propose to develop the site.
Thank you very much. So turning to the council then, how we're talking about how policy one is relevant to the application. I'd be interested to hear your own views on that as well, and how that should be taken into consideration.
Hi, sorry. I'm trying to digest. There was a lot in there, Stuart, and I just think breaking it back, let's look at what this development is for. It's for renewable energy. It's crept into the national development category by virtue of the addition of a solar farm, by virtue of the addition of a battery. So if you look at the 10 turbines and their generating capacity in the description of development, each turbine is around 5 megawatts, collectively 50 megawatts. If those ancillary elements were not proposed, it would be a town and country planning application, not Section 36 application. You would not receive the policy support it has under MPF4 as a national development. I think that's important to keep in the back of your mind, because the addition of a battery, its generating capacity and the way that's been viewed by Scottish Government in terms of bringing that threshold up beyond 50 megawatts is important to consider. And the addition of the solar farm, what confidence do we have that that will actually be delivered? We don't know if that will ever come to fruition or not. It could simply just be 10 turbines. So it affects the way policy weighting is applied when considering MPF4. So the applicant, in my position, I think these elements may come forward, yes, but it's on the cusp of being a national development, so that's my point. And in terms of the weight that then can be attributed to that, we need to consider in the round what impact that has. So there's a balancing exercise that must be struck. We have to consider what impact 10 turbines will have, if that's proportionate to the extent of landscape and visual impacts that you heard about yesterday. The applicant's gone into a bit more detail in terms of what habitat mitigation measures they're looking to deploy in terms of ensuring compliance with MPF4. We haven't contested that in our report of handling. The facts are stated in the applicant's report in terms of what they're intending to deliver. We haven't provided any response as a consultee on that matter. Nature Scott may well have provided more detail in terms of their satisfaction with those provisions or not. I don't believe the council has provided any significant assessment which can inform your decision on that matter. So I'd like to just park it at that, if that's helpful. And in terms of policy one, it is a dual crisis, yes, and I believe the applicants put their position forward pretty clearly in terms of how they've sought to address both those crises. And our position is, as a council, we recognise that. We consent several wind farm developments, several renewable developments. We're inundated with proposals at the moment, and it's an incredible amount of applications that have come into our system. As a team, we have to deal with those. We need to be selective over which ones we then select for to be supported and which ones are to be refused. I think ultimately, being a Section 36, we have to pass that decision over to the Scottish Minister. So it's your job to weigh that decision up. But you'll see from our record how much renewable energy we have supported in Highland, how much support we've given it. It's time and time again used in our reports as reasons why we're supporting developments. It's about finding that balance and applying that balance, and that's where this proposal in particular hasn't reached that point where we're able to support it. So.
Thank you very much. Before I go back to the applicant there, I do appreciate your position and whatnot, but I need to determine the application as it is before me, obviously, and I've not been given any reason to doubt that the whole project won't come forward. So in my assessment, I will be considering it on the whole level. I want to reassure the applicant there as well. But I understand what it is that you're saying there, Mr. Wheeler. But yes, I don't need a response from the applicant on that element of what's just been said. So, Mr. Ennis.
Yeah, I just want to come back on. It was quite interesting. The approach is that essentially the council is very much looking at the turbines as opposed to the combined benefit of battery and solar. I mean, one of the references I'll give you is paragraph 5.38 of the onshore wind policy statement, which is essentially setting out what repowering gives as an opportunity, i.e. starting from a site and saying, what could we do that would make a future redevelopment of an existing site better? And what they say is the major advantage of repowering is they offer the opportunity for co-location with other renewable technologies such as solar PV and battery storage, and also maximising land use through ecosystem enhancement and restoration. If one's looking at that as a scenario, there are reasons behind that in energy policy terms, because what you're actually doing is also maximising utilisation of grid when the wind doesn't blow, and therefore you're bringing in efficiency and resilience. And therefore there is the support to this, because it's an efficient land use, to bring these together to share the grid infrastructure, which if you look back at the white paper is one of the big challenges. How do we build a grid that can manage large volumes of renewable energy that aren't essentially permanently on and are in part at times intermittent? And that's one of the responses, and we see that. But the other key point is they do not separate off this idea of the opportunity for maximising effectively land use through restoration. And that's writ large through the onshore wind policy statement as well. Is how can onshore wind and these mixed sites actually respond both to the emergency in terms of climate change, but also the nature challenge? And it picks out the real work that onshore wind has done in peatland restoration. It says that is something that this technology and this type of development we know can truly help and deliver. And in this context, it's not a generic 168 hectares. It's an area that is directly related to a nationally protected site for that habitat. And in that context, what you're getting is the synergy and the benefits of that. And what I do know is the council say they've recognised it, but really it's for other people to have assessed it. What I'm inviting, and we will be inviting in our closing submission, is for you to add that to the benefits in terms of the weight to be attached to decision making. And it may well be that policy one only got 2 lines in another report, but that may be because the developer in that instance was not promoting the nature and scale of peatland restoration adjacent to a triple SI, and that would be beneficial to the triple SI. So you have to look at this application, this policy, in its context of what is actually proposed by the development. So as I say, there are aspects of this development which we will be inviting you to attract weight to. And I appreciate that it may well have aspects that are out with the core competence of the council and they rely on others, and we can make reference to that. But I think it's important that we look for both aspects to be taken into account in the determination. And that's it.
No, each application will be judged on its merits. When there is something directly relevant there's precedent for, it'll obviously be material to my determination. I'm not 100% sure there that the council was saying that it didn't take everything into consideration in terms of the development, but I think they were talking about the landscape and visual elements of the proposal, which had the adverse impact, which is the reasons for the objection, was based on the 10 turbines. So again, I think at this point, rather than us go backwards and forwards, I totally take that there are in the wider policy context, there are a lot of benefits from this proposal. It's my position that I have to weigh those against the identified adverse impacts, or perceived adverse impacts, I should say. So with that, if people are happy with this, the underpinning overarching policy one, we can look at the more topic specific policies that we've got on the agenda. And natural places is the next one that's on the agenda, which does touch on some of the matters that Mrs. Russell's raised, and I'd be happy to go back to the applicant to hear the views on policy 4 as it applies to the proposal before me.
Yeah, thank you. I'm not trying to suggest that policy 4 is irrelevant. I think it's not necessarily to be given the weight to the determination of this application. And the reason for that is that MPF 4 is to be read as a whole. We find that in Annex C, which describes how we're to apply MPF 4. Policy 11 provides the clarity for renewable energy projects, whereas policy 4 is relevant really to all development, and it's within policy 11 really that you find the kind of balancing tests and the landscape considerations. Policy 11 is quite clear within it. The relevant section up. And in D, it provides that clarification of when they believe that policy 4 should apply to renewable energy projects. And it says development proposals that impact on international or national designations will be assessed in relation to policy 4. I don't believe that it does have that impact on international or national designations that as was discussed yesterday, we believe that it's localised significant effects, so it doesn't really trigger a requirement in our view to look at that. The landscape is adequately dealt with, and we'll come on to policy 11 and look at that in the next topic. That is really the position that we have. If there is an alternative view, I think we've set out what the assessment would be within the hearing statement. For today, I think that's useful just to set out our position.
Okay, so we'll obviously discuss this as far as you believe it relates to the proposal when we come on to 11 shortly, but I'll give the council opportunity to offer their views as to whether they think policy for how that should be considered. I'm sorry, Mr. Whelan, you're on mute there.
Thank you very much. I did have a detailed look at the applicant's supporting hearing statement, and if you refer to paragraph 159 through to 162, I think quite clearly states that, in their opinion, MPF policy 4 doesn't apply to this case. I don't think that's what we heard initially from the applicant's side at the start of the conversation, that every policy needs to be considered. MPF 4 policies need to be read in the round, and I would particularly point out that Part A of the policy does apply. There's no doubt about that. I think, particularly as well, Part D. It needs to be read alongside policy 11, the energy policy specifically, but if you look back through other appeal decisions, time and time again, policy 4 is referenced, it is considered for these types of proposals. By virtue of not having an impact on, say, a national scenic area, and that doesn't mean that you can disregard the policy. The proposal also has impacts on much wider ranging issues, including landscape and visual, which all fall under the natural environment. So we need to consider the whole of the policy as well.
And is there anything in particular that you'd like to raise about the policy, or should we move on to policy 11? I think with the different positions from the two parties on the policy, I'm happy to accept those and move on if that's the position.
I'm content to move forward on this side.
Mr. Ennis?
I've just got one point. It's when reading any policy document, part of it's interpreting it correctly. And in relation to this document, you can say you have regard to all the policies, but then you have to work out which policies are directly relevant to the proposal, which you're going to give greater weight to in your determination or consideration of the policy within a plan. So it may well be that the policies on the face of it are relevant. You then have to go to the most relevant policy and say, well, how does it fit? And we're going to come on and talk about policy 11, but it clearly sets out a framework for considering energy projects and the wide, diverse range of energy projects. And within it, it's got the express statement development proposals that impact on international and national designations will be assessed in relation to policy 4. Now, that must have a reason as to why they're saying that. Otherwise, we would just leave it at that and you wouldn't need to say anything. Why is that statement made? Because it's essentially saying that notwithstanding the balancing exercise to be undertaken in policy 11 in relation to matters, if you engage an impact on a national designation, that's not covered by policy 11 and you have to go off and do the test under policy 4, and they'll ultimately either come back into the balancing exercise. Otherwise, those words are utterly meaningless if at the end of the day we just apply policy 4. And what we're saying is that if you've got to interpret the policy, so when it says you have regard to all the policies, it doesn't just mean it's a blancmange of just words. You've got to sit and work out how the policies work together. And it seems to me on any reasonable interpretation of policy 11, what it's saying is policy 11 and the balance, we are not superseding policy 4 in relation to national designations and those tests that apply in that context. But equally, it's sort of understood that if policy 4 is read, it starts off saying unacceptable impacts on various resources, but it then goes through the various sub-paragraphs which set out the framework for establishing whether a particular effect may be acceptable or unacceptable. And once you get below the threshold of the national developments under paragraph D, you're into a balancing exercise of the benefits of the economic and social, environmental, or economic benefits. That's a balancing exercise. And similarly, policy 11 ultimately ends up being a balancing exercise. And what in terms of why it makes such a logical sense to say that policy 11 has it unless it's national, is it's undertaking a balancing exercise as well. And if you're trying to find overall policy compliance, you're not doing separate balancing exercises because that, as I say, is about acceptability. So I think that's why we're saying that essentially policy 11 is the right one if you're testing it truly against compliance with NPF 4. Where that balancing exercise arises. Otherwise, we're doing two exercises. It's got special criteria that are given weight in terms of 11, which are particularly relevant to energy projects. So that's why it sits within policy 11 that balancing exercise is carried out. And that is logical relative to national, where it reserves that for policy 4. And you have to go through those policy 4 assessments in terms of it. Otherwise, the sequence of policies doesn't make sense if you just say, well, I'll apply everything. And lots of different balancing tests. Balancing tests are about those acceptability tests of whether it complies or not with policy. As if you have more than one, I mean, that doesn't really make sense in the context of trying to determine acceptability if that's what's being done. And that's how these policies are phrased. One's on an unacceptable basis in the policy 4 and sets out the tests. And then 11 is about the balancing exercise for energy projects. And so I think that's the logic. What we're not saying is that you utterly ignore landscape and visual impacts. They are incorporated into the balance. And where you have a designation, the effects on a designated landscape will also have a bearing in the balance of where it sits and how important it's taken into the balance. So it's not lost, it's just getting transferred into the balancing exercise in 11. That's our line. Obviously, there's a difference of view, but just to explain that context, before we get to 11, because I don't want to say that we're saying how we get to of that balance and why we say it is. It's not trying to discount in any way the landscape and visual impacts being taken into account, or indeed local landscape designations or other types that get taken account, but it's in policy 11.
Thank you very much. Now I take that position, and I take the council's position. And one of the exciting things about being at the forefront of decision making with a new policy framework like we are is that we don't. Well, we get to experience it for the first time, I suppose. I will just go back to the council briefly on that. I think Mr. Finlay wants to say something.
So apologies for perhaps slightly disappointing your excitement, but the Kirkin reporter, and whose views were accepted by Scottish ministers, seems to me, gave some considerable regard to policy 4 and its interaction. So that's CD 8.3, just for your note, at paragraphs 48 to 54. So that's the first point I made. The second point is that if you just ignore policy 4D in particular, you will ignore what is a change in the policy approach that wasn't an SPP, of greater protection being given to local nature conservation and landscape areas. Test has been ratcheted up. And thirdly, notwithstanding what I've just said, the council's accepted, and indeed it was part of our response on policy 1, that policy 11 is the main policy against which to judge wind energy developments or renewable energy developments. And much of what Mr. Innes has said about policy 4 could also be applied to policy 1. But whilst policy 11 is the main policy, it doesn't negate the requirement to consider and assess policy 4 as well.
I mean, I think if we continue to back and forward on this one, when there's two, it's totally. People have differing views, and it's not for you to convince me or each other today. In your closing submissions, you can make your thoughts known on this matter. But I'm happy that I understand the position of both sides with regards to policy 4. And I think that it'll be most efficient and probably most beneficial if we look at policy 11 now, which is the specific policy on wind energy that involves different criteria for our consideration, notwithstanding that there are other policies that I have to have regard to. We'll move on to 11, I think, at this point. I think that we'll take more from this session if we advance. So I'll move forward, and I'll ask Mr. Russell again to give us your interpretation and your advice on this one first. Thank you.
Thank you. I think initially, I think it's quite important to recognise that policy 11 supports all forms of development, and within criteria A, lists what those are and sees the benefits of all aspects, which includes storage, the battery storage that's provided, as well as the solar. And it goes back to what we were saying with policy 1. You know, this development is looking to kind of maximise all of that, and all of that is supported really by the policy. I don't think that is in question. One of the requirements, and I may jump about a little bit to C first before going to B, and just the reason for that being that B also talks a little bit about location and potential landscape impacts, etc. So I think it's worth just jumping to C, which also sets out a new requirement, and that is that development proposals will only be supported where they maximise net economic impact. And note that includes local and community socio-economic benefits, employment, and associated business and supply chain opportunities. With regard to that, we do believe that the applicant does maximise the economic benefits of the site. And I think there's quite an important distinction to be made there. Within the Council's hearing statement, there was reference to the fact point that it wasn't significant economic benefits, and that is not the test that's within the policy. It is to maximise, and I think that the applicant does that really in two ways. The beneficial effects are because the applicant has a very significant experience of delivering developments in this local area. They have existing local supply chains and synergies with local businesses to help them make the most of the development in the area where to go ahead. And I would kind of refer you to Appendix 1 of the NPF4 updated planning statement. That's our CD 1199, which provides a more detailed assessment really of the likely minimum net economic contributions, which we believe support compliance to this element of the policy. We'll come on to the sector day later, but I think the second element of that is I do believe that there's added weight of the sector as well as what the applicant can provide in kind of crystallising the economic benefits of a sector as a whole, which the applicant is also engaged with. Turning back really to going back to criteria B within the policy. I think this is where we begin to see the step change that we were introducing at the start, this difference from previous policy in SPP that was before it. That to meet this challenge that's set out in the OWPS, which provides the context, basically developments for wind farms in national parks and national scenic areas will not be supported. And it goes back to that paragraph in the OWPS, which explains that outside these areas, that the policy position has changed and the criteria for assessment has changed. So it's very clear that it's not the same kind of spatial framework that went before it. It's only in these very specific areas where it won't be supported. And then it also helps, I think, is this ultimate phrase that's been used for many years in planning, the right development in the right place. I think what NPF4 Policy 11 does very well is begin to kind of focus in on what is the right place and to help guide decision makers. And that is provided predominantly within E2, which talks about the effects where they're outside of those areas. And that is that significant landscape and visual impacts, recognising that such impacts are to be expected from some forms of development and renewable energy, where impacts are localised and or appropriate, design mitigation has been applied, they will generally be considered acceptable. That is a fundamental change. That is how we're going to deliver the 2030 targets, that there will be more of this change, that as the OWPS sets out that we discussed earlier, the machines need to get taller and that there will be landscape change, and this is very much reflected in this part of the policy, and I think that really gets to the crux of the difference in the approach. With regard to that, I think we're very comfortable that we have carefully designed the development that is highly localised for the type of development that's being proposed, and that appropriate design mitigation has been provided. We can discuss that very briefly in a few moments. But basically this policy provides overwhelming support for renewable energy. But that's not at any cost. We recognise that. It is clear that the applicants still need to provide the evidence through the mitigation process that they have gone through. That is very much what it says at the start of E. In addition, project design and mitigation will demonstrate how the following impacts are addressed. It doesn't say that there's any other test of that. They just need to set that out. And then criteria 2 of that talks about where there's significant effects and being localised, being generally acceptable with mitigation. So I think the mitigation element is important, and the flow of that mitigation argument is already set out within paragraphs 29 to 48 of my hearing statement, and would refer to that. I think it's been a very, very detailed process over a number of years to get to the point of the final proposal that's before you. And part of that, really in summary, is that the choice of the turbine heights, the commitment to use smaller scale turbines, and trying to fit as best as they can really with the turbines that are in the surrounding area, and in doing so, that they reduce any requirement for nighttime lighting and reducing that, mitigating in that respect. The layout has gone through that clear iteration process. Ultimately, the Highland Council, I don't believe, are suggesting that any move of the turbines or that type of mitigation would address any of the effects that we have identified. What they have suggested is potentially removing turbines, but that is a different scheme and not the scheme that is before you today. So I think that is kind of our overall summary of the policy and where we believe that there's a significant strength. All of those considerations then need to be balanced, and Mistress will come on a little bit about the changes that have been seen in decisions, but ultimately it really comes to that final point, which explains that, you know, even where all of these impacts are considered and taken into account and addressed in terms of the mitigation that's been proposed, and considering those impacts, that significant weight will then be placed on the contribution of the proposal to the renewable energy generation targets, and also to the greenhouse gas emission targets or reduction targets. So I think that's where you've got balance. There are a lot of different considerations, and it's really only one element, one very kind of small element to that, where the proposed development results in some limited significant effects. We believe it complies with the policy, that they are localised and that mitigation has been proposed, and balancing that also against the significant weight. We'll talk a little bit more about really how we believe the weighting. I think that's one of the further questions that we're going to discuss later on, so we'll come to that then. Just to pass over to Mr. Innes.
Before we pass over, can I just ask a question there? Sorry. I think in the absence of any guidance at the moment about what localized impacts are, I'd be quite interested to hear your interpretation of that and how you've confidence that these are localized impacts. Just for my own records and for my own consideration when I'm considering this policy in particular.
Perhaps we perhaps stop there and let the council respond to what we've got, and I'll pick up your point when I address decisions.
Yeah.
How to
Okay.
interpret. But I think I share your concern about what does localised mean, and there's been a range of decisions. I don't think they're necessarily entirely consistent. It's a judgment based on the scale of the development and considering the extent of them and breadth of effects, and are they disproportionate? I think probably one which that comes to mind is Shepherd's Rick, which is one of the ones we're going to be looking at, where it was accepted they weren't localised. So that's an example of a non-localised project and how the decision making went there. But as I say, I think that's one of the examples. And then there's other treatments as well. We did. Saying the best things, I'll come to it in the decision making, which is probably the best.
Yeah, no, that's good. And I also have a question for the council, actually, based on what was said, because I did notice in the council statement it was pointed out that I don't think it said that there wouldn't be significant benefits. As I remembered it, it might say that, but I'm talking about the maximisation of the economic benefits. Again, we're in that period with an absence of guidance at the moment, and I think that the council statement said, without me finding the actual paragraph, that there wasn't any more than usual. So it wasn't demonstrated it was maximised. But where we are without the guidance at the moment, I was wondering if you had what would maximised benefits look like? Again, we're finding our way in with these sorts of things at the moment, and without the guidance, it's difficult for an applicant, I believe, and I think we've seen that at this point where applications were submitted prior to MPF4, demonstrating maybe that it's been maximised. But I'd be interested to hear. You can talk about the whole policy, but as part of that, if you could just mention the maximisation, I'd appreciate it. Thank you.
Thanks very much for the opportunity to speak on this. I did review the socioeconomic section of the environmental statement. I reviewed the hearing statement as well put forward by the applicant. Going through the detail there, it's very much, this is a commercial-led wind farm development. We will pay the Scottish Government's rates in terms of community benefit that's applied equally across Scotland. The only overage I could find in what was being offered was a £50,000 contribution towards improving the electronic vehicle network for Highland. In my mind, viewing what's on offer is akin to any proposal that was being determined under SPP. MPF4 comes in saying, you know, economic benefits must be maximised, must be. So it's a requirement of this development. Going through what's been submitted, you could state there's an absence of regional strategy on that to say, well, what does Highland expect developers to contribute? And different developers have come forward with different initiatives in terms of how they can benefit the local people, how they can offer, you know, reduced energy bills, improve home insulation. There's various tacks that they could take to demonstrate how this proposal could maximise the benefits to the local people. And it's about that just transition. If we're going to accept national developments in this area of Highland, how do those local people benefit from that? You could argue that everyone benefits from it because they've got cheap forms of energy and therefore reduced energy bills across the UK as a whole. But that's not specific to the people that are most affected by these developments. Going through what's been submitted, how would it be benefited? You know, how could it be maximised? There's no manufacturing. If you look at this proposal, it's very much akin to any other proposal in Highland in terms of onshore wind. I'm not belittling it as an industry. They provide community benefit. They provide jobs. The stats are there in the environmental statement. We're not disputing the stats that are there, and they are well evidence-based because of the Hassery, and they know what's been produced by that. My point is, I don't see anywhere in the submission how that demonstrates maximising economic benefit. It's the status quo, it's continuation. And in their statement, they said they were going to rely upon what's going to come out of the sector deal. So I read the sector deal, and it says we're going to come forward with a framework of how we're going to address this next year. So no help to this decision moving forward. So yeah, I do not see how they comply with the policy, but again, it's only one policy in a framework of policies. Perhaps it's more of a political addition rather than anything else that's been done in NPF4. You could also refer to paragraph 65 of Kirkin, that's been addressed previously. That's again in the supplementary report.
Okay. Before I ask you to go through the rest of 11, would the applicant have anything additional that they want to say about the current situation with maximisation of benefit?
Yeah. Yes, sir. This isn't about community benefit. That's can be a byproduct of it, and of course, there's restrictions on that's done. So one of the issues is obviously in terms of the economics is maximising the supply chain benefits locally. We have set out in detail how Scottish Power Renewables have already developed in this area and the magnitude of procurement through the suppliers in the area. Now, that takes work because you have to work with local suppliers, you have to make sure that they get the opportunities. But having already done that, we're building on existing relationships of building on the skills and expertise that there is already in Caithness and in the north of Scotland to actually deliver onshore wind farms. And that then is actually a key economic benefit. And the point about this is that we have analysed the market, and we do believe there's a supply chain in the north that can take the benefits of this project. That's the primary driver of the economic benefits, is making sure that that process is followed. And does a lot of the may seem quite generic at times, the sector deal. What it's trying to do is make sure that we're matching the skills required for the future economic development of the renewable sector and the onshore wind sector. Again, that's critical. The Scottish Power Renewables have an extensive track record in working with others in skills development to actually ensure that we have the workforce that enables us to take these matters forward. So, as I say, I don't think we come at this cold. This particular developer, and this application is made by Scottish Power Renewables UK Limited. It is personal to them that the consent will be granted. Have a track record of working in this vicinity with a range of contractors, and have committed to going through the process to maximise that local content. And the fact is, there are contractors and there is a skills base up in this part of the country which can take advantage of that. And that's important, because there are other parts of the country that don't have that skills base, where you're having to start saying, well, actually, we're trying to stimulate local contractors to have the skills, equipment, etc., to be able to do it. That's not the case. There are contractors up here, and we've demonstrated through the figures that we've set out in respect of House 3 how that's benefited the local economy. So this isn't an absence of a supply chain. It's about stimulating and further stimulating the opportunities there and creating that real benefit up here.
That's useful. Thank you very much. I'm going to go back to the council now and let them talk in the round about policy 11. Thank you.
Well, thanks very much. Just following up on just a final point on that in relation to policy 25 of MPF4 as well. There is no community ownership of the scheme, just to make that point clear. So point B doesn't receive any additional support. So you've heard from both sides our position on point A of that policy 25A, continuation of the supply chain. It's the applicant's position on that. In terms of going back through policy 11, just give me a couple of minutes. We started off the part A of the policy, and we talked about the in-principle support being offered for renewables across the board. I'm not disputing that. So wind, solar, battery. This perhaps wasn't stated in the applicant's position about how much that battery means in terms of does that equate to having an additional turbine? I don't know. It's got a storage capacity, and I'd question how much additional storage capacity that is in comparison to the generation of a wind farm on a 24/7 basis, rather than storing energy and releasing it to the grid as and when it's required. I think going through the crux of policy 11, part B was explained. Yes, it's not in a national park, it's not in a national scenic area. Tick. All right, so let's move to the next one. So in terms of C, we've talked about maximising net economic impact. It's questionable if that's the case. After our hearing statement. For D, proposals impact on national, international designations. Again, that's not the case as I understand it for this. Moving to E. So if you're out with the designated sites and you're out with the SSIs and you're out with the parks, this is the rest of Highland as I see it. Part E is pretty clear about how proposals should be designed and brought forward. So in coming forward with a wind farm development proposal, you need to consider a range of factors. The key one in this one, how the proposals impact on the communities in terms of visual impact, that's part one. And two, the significance of the landscape and visual impacts of the scheme. And of course, there's acknowledgement that if you're going to have onshore wind, you're going to have some significant impacts. That's accepted, and that's reflected in that. The question is, where those impacts are localised and appropriately mitigated, then they're going to be acceptable. Now, you asked about the question about localised impacts. There's a very flat landscape here. You've got 360-degree visibility. You've got a road that loops around the coast where you're going to have sequential impact over and over and over again as you travel through this area. And it's not just well, it's a low populated area. This is as far north of the mainland. It's attracting multiple people travelling on journeys for recreation, and part of the land's end to John O'Groats, a long distance cycle route. You've got extensive numbers of tourists in this area, but equally you've got local people as well. Myself, I've been there, I travel there. I live in Highland, but I know of multiple people who have travelled and congregate for events in that part of the world. It is a valued part of the landscape and valuable to the communities that it serves as well. Now, in terms of going back to policy E2, in our opinion, as evidenced by the ZTV alone, shows how extensive the visibility of the proposal would be, and that's theoretical, obviously, and then you have to use the montages and the further EIA to establish exactly what it will mean when travelling through the area, when living in that area. In our opinion, the effects are far beyond localised. We are identifying significant effects out to 22 kilometres, as I understood it from yesterday. Now it's up to you to decide if that is localised. Our position is that is not localised. We don't have topography to screen this development at all. And I think in terms of how the scheme has evolved and its mitigation, all I could say is how much regard have they had to the landscape capacity study for this area. The council went through a rigorous exercise of identifying where they want to see onshore wind development. The appendix to the onshore wind energy SG contains the landscape sensitivity study, and that identifies potential for consolidating wind farm development around Stripster. This is not consolidation. This is something completely different that maximises the envelope of wind farm development across the central part of the landscape. There's incompatibility there in terms of where the existing wind farms consented and built are with this proposal. The spacing, the design is different. You can see that for yourself, and the question how much regard therefore has been given to the landscape study that's been undertaken, and it's quite clear from onshore wind policy statement that we're supposed to have regard to those documents. They still hold true, and if you look at the decisions, they're not overridden by MPF4. They have to be considered alongside MPF4 and form part of the development plan as a whole still. So our position is it's not localised effects. And the design mitigation, well, what can you do? You heard that they've kept the turbines to a height where they don't require aviation lighting. But other than that, you can't hide these. They're there to harvest the wind, and they are substantially larger in scale. Yes, that's expected. Our position is no mitigation could have been applied to this development to make it acceptable in this location. It's the wrong location for this development. Moving on to other aspects of the policy, they cover a variety of factors. They are echoed in what's already in the Highland Wide Local Development Plan Policy 57 and also 67. So I don't think it's worth going through every single sub-bullet point there for the case of time. I think it's worth possibly reflecting on how other reporters have considered the acceptability of proposals in the planning balance, where you don't have, where proposals are not compliant with 11 Part E2. So some reporters have concluded that even if you fail Policy 11 Part E Part 2, that the overriding urgency and the need for energy and the benefits that the scheme has outweighs those impacts. It depends on the severity, I would say. You have the right as decision maker to make a judgment here to say, actually, they're far from localised effects. Significant impacts across a wide area. There's no mitigation. It doesn't conform to how the pattern of development is taking place in this area. And on the pro side, there may well be benefits in terms of they can do to habitats in the environment, and what they can do in terms of making a contribution towards this 20 gigawatt target by 2030. But if you look at the information that's come in on that and what a contribution it would make, we are edging closer to getting to that point. We have multiple schemes in the system. You can see the figures that are quoted in the applicant's paragraph 54. So we've got the new quarter one statistics from 2023 out. We can see that if everything in the pipeline does come to fruition, we're already exceeding the 20 megawatts by 2030. Now, if the onshore wind sector deal is to be realised, my understanding is that pipeline will be delivered faster. And there's acknowledgement in that statement that these schemes that already have consent, some of them will not be built out. Some of them will go through redesign, they'll get bigger. I believe that there's still sufficient time for those schemes to come back through, and with in principle support for development of wind farm activity on that site, I think it's going to be a relatively simple exercise for them to increase those blade tip heights to something that the market can deliver on. 150 metre turbines, 200 metre turbines. You can see it happening. We're getting those applications all the time.
We're going to move on to what can be taken from recent decisions and things. We've started onto that there. I mean, again, not talking at this point about repowering and focusing on what's before us rather than what might come. There's a couple of points there, and again, the landscape capacity study and the sensitivity study. We're going to come on to that, I think, as part of item 4 when we talk about the LDP and related guidance. I think I will just go across to the applicant to respond to some of the points that have been made there, bearing in mind we are going to be dealing with some of that further on the agenda. But if there's anything in particular the applicant would like to say in response, I'll take that now.
Thank you, sir. I think we'll come back later on in the agenda and deal with a couple of those matters, because actually that morphed into development plan, local development plan. I think we'll deal with that then, because that's separate, and we'll come to the views on that. And equally, we'll come to the views on some of the things that have been said about the fundamental site. I mean, again, we'll perhaps leave that to that session. What I think it might be helpful to move on to is the decision making, if that's okay. So if we move, unless you wanted to have, it's now 11:30. If you want to have a break.
Well, I think, yeah, we could have a brief 15-minute break. Come back to talk about the decision making, and then hopefully go into the Highland-wide local development plan as well before we break for lunch. That'd be quite useful if people would like to stretch the legs and take a soft drink. We'll come back at 11:45. Thank you. Morning, folks. Thanks for getting back. We'll just jump straight in here. So the next bullet point that we've got to look through is what can be taken from policy 11, recent decisions, and elsewhere in MPF4 about how these considerations should be balanced with each other with the overall need for renewable development as set out within the onshore wind policy statement and within policy 1. It's the overarching policy. So again, I'm going to start with the applicant and go to Mr. Innes. Thank you.
So what I'm going to hopefully relatively briefly set out is essentially an approach to decision making which has been adopted by the Scottish ministers fairly consistently post the adoption of MPF4 and the publication of the onshore wind policy statement in relation to Section 36 decision making. I think it's, if you look at the Scottish ministers' decisions, their letters actually now have a very clear structure, and the decision making follows a fairly set process where, when it gets to the bit about having got over the introductions, they set out what they describe as determining issues, and they then summarise any negative impacts or effects that the proposal have that are of significance. They then consider the positive benefits of the proposal, and then do a policy analysis, bringing in the onshore wind policy statement and other matters in relation to energy, and then considering planning policy. And then bring that together under a heading called acceptability. And in my submission, if you actually look at that core end piece, it's a straightforward balancing exercise that they undertake at the end of the process, irrespective of how they get there. Ultimately, the exercise that policy is set out in policy 11 is undertaken by the ministers in a slightly different way, because the considerations are slightly broader and they're bringing in their energy policy. But I think there's now a very consistent pattern of the way that they are thinking relative to decision making. As I say, it's set out in the structure of decision letter, which is now fairly settled. In terms of the balance, what I want to do is initially look at two refusals, which I think are at least set out some indication of the Scottish ministerial thinking. But at the same time, I do caution before I go through any of these decisions that each application has to be considered on its own merits. And to a degree, these are not binding precedents, but they give some illustration of the approach and to some extent the balancing exercise which has been undertaken in the context of other projects. So I'm going to kick off with the Sheardrum decision, which is document 008015.
Just give me a second to open that. Sorry, I'll follow along. Okay.
I'm just going straight to the decision-making letter, and this one, I don't think there's too many facts, but I want to just kick off with page 5 of the document, which sets out the various consultee responses, just so that you've got a bit of context. In terms of this case, there was an objection by Argyll and Bute Council, the relevant planning authority. Their objection was threefold. First, based on significant, page 5 it's summarised, significant adverse landscape and visual impacts, including cumulative landscape and visual effects on various receptors, including those in South Knapdale. And the reference to South Knapdale is that that is an area of panoramic quality, which is the Argyll and Bute equivalent of a local landscape area. So that's why that geographic location is specifically stated, and it was accepted by the applicant that there were localised significant effects on that particular resource. And then it talks in and around Clachan, which is a settlement, and thereafter references various ferry routes. The second objection was based on impacts and setting of Dunscaig, which is a fairly impressive scheduled monument with that has views over West Loch Tarbert and is say was recognised, and then there's aviation matters. Also of note is Historic Environment Scotland objected to the proposed development in the national interest due to the proposed development's effects on the integrity of the setting of Dunskeag, Duns and Fort, and scheduled monument, particularly in views from the sea. That was the particular context. It was turbines were appearing behind the fort from views out to the sea. It actually comes to the decision-making of the Scottish ministers at page 19. What we see is that the Scottish ministers, in the third paragraph down, come to the crunch of the decision. And the Scottish ministers state there that they considered both the reports, because this is another one where there have been an original report and then a further report to reflect MPF4 and onshore policy. They say that they note the report's consideration subsequent conclusions consider that although the significant local landscape and visual impacts would be acceptable in the context of the net economic benefits of the renewable evidence would be delivered if the proposed were deployed. So I think one thing I'd draw is what they're doing, what the Scottish ministers are doing, is they're weighing up that effect, the landscape and visual effects, against the benefits, saying, how does that fit? And in the context of the landscape and visual benefits, the balance tipped in favour of granting consent. It was obviously in this particular instance, however, because they then went on to do the balancing exercise of the finding of the adverse effect on the setting of Dunskeag, scheduled monument, and that failed the balance. It would not. So what they are doing is considering those effects and doing that balancing exercise against them, which is it's a bit akin to policy 11. You're looking at the effects and giving significant weight and then balancing them. So that's, as I say, an illustration of the Scottish ministers finding that the landscape and visual effects did not tip the balance, but solely the ones relating to the second, I think refusals are perhaps somewhat a better illustration of the balance than those that have got through. But let's secondly look at Cochrane, which is obviously a fairly recent decision. And in the first instance, what I propose to do is to go to the reporter's report, which is document CD 18018. In this one, the first reference is probably taken to page 23, paragraph 3.1. Now, we see that chapter 6 of the EA report, and this is the essentially the setting out the relevant findings of the EIA, and it's identifying significant effects. But what we see there is that I'm just going to flag two matters. Bullet points 5 and 6 are the acknowledgement of two significant effects on South Ayrshire scenic area from about 4.5 to 9.5 kilometres to the east, and from upper sides of Stincher Valley, and also within Dumfries and Galloway, the Galloway Hills regional scenic area across west slopes of the Merrick foothills. So again, we're seeing a whole series of acknowledged significant effects. And the next bullet point is viewpoint 17, 19, 21 and 22, open brackets, bar trail, cumulative in succession effect. I just flag that because that comes back into the decision making later. So I'm flagging that, and also the impacts, as we'll come to, on the Merrick, which is ultimately where this decision ended up being determined. In terms of the reporter's findings, if you go forward, it's quite a lengthy report, this one. Paragraph 1, page 143. You'll get far more detail if you want to read the whole report. So I'm just sort of taking you to the summary, but it's got 3 reasons why the reporter says the particular application fails the balance and should be refused. 10.38 deals with the impact on the Merrick, which is the highest hill in the southwest of Scotland, and is located in a wildland area. And that's 10.38 is the findings in relation to that. 10.39 is a subsidiary finding about the bar trails, which were acknowledged to be significantly impacted upon in terms of the environmental impact assessment. And section or paragraph 10.40 is a further factor that the reporter has taken into account is the number of overlapping environmental designations that cover the application site. And this included the Galloway Forest Park, the Galloway and South Ayrshire Biosphere Park, the Galloway Dark Sky Park. In this case, that these are either not generally considered to be key designations, or Sky Park have found that the nighttime main cuts these overlapping designations are strongly indicative of the way in which the area has been recognised and valued. And he therefore incorporates it as part of his reasoning, ultimately, of recommending refusal of the application. In terms of the ministerial decision making, that's set out in document CD 008.017, which is the decision making.
Yeah, that one.
Again, I'm not going to trail through all the decision making. The general point that I make is set out on page 20 of the decision letter, because again, that's ultimately where the reporters, having gone through the various iterations of the decision making, have come to this overall view. And at the top of page 20, you see that although the Scottish ministers consider that the detrimental local landscape effects on the quality of a number of environmental designations and locally significant effects on use of the bar trail would be acceptable in the context of the net economic benefits and significant remote benefits that would be delivered if the proposal were deployed, the significant visual impacts on the Merrick would not. And again, what this is another example of is that in the overall determination, the Scottish ministers have actually disagreed with the reporter, and they've done this weighing up of what gets into the threshold of being unacceptable. And as I say, I think that's an approach to decision making that the Scottish ministers have brought. And I think if you look at those decisions, it recognises the high threshold that the Scottish ministers have set before that bar is crossed in terms of the balancing. And that's a very simple point, but it's illustrative of those two matters in those two cases. In terms of live decisions at the time of MPF 4, we've got 2 before you where effectively the reporter's decisions were changed from that which they originally recommended under the previous policy position and that which prevailed under the production of MPF 4 and the onshore wind policy statement. And again, I think reading it, if you read the national decision making, MPF 4 is part of it, but it's also seen in the context of the onshore wind policy statement in terms of onshore wind. And in terms of those 2 decisions, I would suggest that Clash and Darrick, which is 8, 13 and 14, is an illustration of a straightforward recommendation for refusal based on landscape and visual grounds, overturned by the reporters because of the change in weight to be attached to the benefits. And it's a simple exercise of that changed weight resolve matters. Possibly of slightly more relevance would be the Shepherd's Rig decision from Dumfries and Galloway, because at least it was dealing with a designated landscape and impacts on that. And I think I was looking at the Shepherd's Rig report. 12, document 812, which is the updated report from the reporters. I think the facts always turn on the visualizations and material before them, but I think in terms of getting a summary, I think it's fairly summarized in document 812, page 30 to 31, where effectively they summarize their overall conclusions, make specific findings in relation to the project's effects on the Galloway Hills Regional Scenic Area, and that is essentially a local landscape designation. And in terms of the effects, they were both from the scenic area and views to the scenic areas appear to have been of particular relevance. In terms of discussions about MPF policy 11, paragraphs 3.6 and 3.7 and 3.8 are of potential relevance. And in terms of they carry out the balancing exercise in terms of policy 4 and say the benefits outweigh the effects in the regional scenic area. And I'm going to very briefly go to the decision making of the ministers in relation to that particularly, which is 010, 810. What I think is quite interesting, if you look at pages 16 and 17, we have the Minister's consideration of national and local policy.
Right, my computer's just stuttering over this one. Won't be a second. Okay, so pages 16, 17.
So dealing with national and local policy, and what they say is that then say the ministers summarise the planning authority's decision. They then summarise various findings of the reporters, and it's also got the discussion about policy 4D1 and MPF 4. And the only point I make at the end here is that you see that in the penultimate paragraph under national and local policy that there's then a discussion of the OWPS and MPF to deliver onshore wind capacity and the strengthening of policy support. And they then essentially reach their own conclusion. The rest is setting out what other people have said. And their own conclusion, when you get to it, is the Scottish ministers acknowledge that the proposed development will result in adverse visual impacts. Visual and landscape impacts. The Scottish Ministers have had regard to the balance of these in relation to the benefits of the proposed development and consider that the proposed development is acceptable on balance in the context of benefits it will bring by contributing to renewable energy and climate change targets. Now, that's direct wording effectively to policy 11 balancing exercise. So all I'm saying is that from what I've read here, the ministers noted all this debate about 4, but when they've reached their conclusion, they've used the language of policy 11 in terms of the balancing exercise rather than the one in policy 4. I've dealt with refusals, I've dealt with the change in positions, and in relation to the question of localised and appropriate mitigation, in Mrs. Fisher's statement, inquiry statement for the hearing, which is document 11.1, at paragraph 2.3.5 to 2.3.12, she sets out various decision making that has considered the question of both localised and mitigation, and set out there those findings. I think at best it will always relate to the particular scheme, but it does seem to recognise that in terms of wind energy development, localised can mean quite an extensive area if you look at that various decision making. In terms of CD, the Kirkland decision, which I think we've has already been referenced, which is CD 8.03.
Yeah.
I think the reporter at 69, 70 and 71 tries to reconcile the wording there in terms of policy 11. And I think that's essentially a finding that he doesn't think that the effects were localised. And then he also goes on to deal with what he understands in terms of appropriate mitigation. I think in that context, he says that irrespective of whatever you think about the wording here, ultimately it all ends up in the balance, because it's the effects are about mitigations of effects, and the effects go into the balance. Now, there is, in my submission, a distinction between mitigation and suggesting a different scheme. Now, as far as I understand, the council in respect of this scheme response in terms of mitigations to remove turbines. They're not saying that the current scheme could be improved by moving turbines. Their only recommendation is deletions, and we've dealt with that in detail in the landscape and visual session and the evidence we presented there. But they're not saying that anything should change in relation to the scheme that's been put forward. And I think that is important, because you could have scheme that had failed to appropriately mitigate. Furthermore, in terms of mitigation, your project design and the scale, etc., is all part of it. And we've set out a design rationale. I think the distinction here is that the council, and we'll come on to look at it, have a vision that meets with what is said in essentially their supplemental guidance. And then there's also guidance provided by Scottish Natural Heritage, Scottish, well, it was SNH then, Nature Scot, in relation to designing wind farms. And it's a national design guidance and advice. And, you know, we can come and consider that when we deal with the supplemental guidance. But I think ultimately, that if you look at the decision making, ultimately everything ends up in the balance. So even if you find that the effects are not localised, then you end up in the balance. It is not the end. What we say in this case is that our ES and our assessment has found that the effects are localised. The council are claiming that they are not. That doesn't lead to unacceptability. That goes back into the balance and the relative weight attached to the effects. So I don't think it's not a question of unacceptability. It's a question of, it's phrased in the way that it is that if you're localised, generally acceptable. It's not that that's a negative, it's generally acceptable. So if it was localised, it would be generally acceptable. It doesn't mean it's not acceptable if it's not. But as I say, our evidence is that it is localised based on our assessment. That is we've gotten that. So I think in terms of what is localised, there is no guidance. We've got the decisions that have, and they seem to be out to about 10k. If our evidence is acceptable on the effects, most of the significant effects in terms of this project are well within that and well below that. Obviously, the council are claiming it one viewpoint, it's beyond that. For a couple of viewpoints, it's beyond that or about that. But that's the extent of the disagreement in landscape of visual terms. What I've just got one last comment is that in relation to none of these other decisions has I don't think we've seen significant writings about the habitat management plan and its value. I differentiate potentially this decision because of the nature of the habitat management plan being directly associated with the SSSI. Means that it is of greater value and connectivity. And that's a factor which you would also have to take into account. And so what you haven't got in these exercises is that the very strong positive support from policy one there as well in that context, because as I say, there may well have been differences. But I say in this instance, we would invite you to have regard to that as well. So I've set out the general position, sir, but as I say, these are not binding or in any way. What I've tried to do is set out the approaches which I think the ministers have adopted, and also an understanding of where some of the decisions have gone relative to the introduction of MPF4. Thank you.
Thank you very much. I'm going to go to the council now to see if there's anything that they'd like to add to that or to say in response to the evidence that's just been presented.
So just changing over microphones. Essentially, Mr. Innes was dealing with three matters. The first was a more general approach to what difference it's made to decision making. And in our submission, there's a useful summary of that in the Sanker decision in these supplementary reports. So that is CD, well, certainly in mine, it's CD 819.
Yeah.
And I'm looking at page 236 of 239.
Bear with me a second. Yeah, I have that.
And so before I take to the particular paragraph, can I say that, firstly, I agree with Mr. Innes that each decision is obviously fact specific, so you've got to be careful what you take from it. Secondly, they're not all entirely consistent one with the other, notwithstanding that Scottish ministers are the ultimate decision maker. But again, that's probably no surprise and hasn't changed with MPF4. So those are two caveats. But if one gets to paragraph 4.5, I think it's Christopher Warren, but anyway, he says, in my original report, he found, I do not consider that at this present time there's been a tangible shift in the policy of a scale or nature which would be capable of being pivotable, that is, granting or not grant of wind farm. Having reviewed the terms of MPF4 and AWPS, I now consider that a tangible shift in planning policy has been made at the national level. In my view, this is likely that this shift may be sufficient to result in some wind farm proposals which would previously have been refused under the former policy regime to potentially now be granted consent. And that seems to us to be a succinct summary of where we've got to. There has been a shift. And Mr. Innes has referred to two examples where that has taken place. Clash and Derrick, and he was kind enough not to point out that I was on the losing side, having won in round one and then lost in round two, and also Shepherd's Rig. And they're examples of that. And I think Mr. Freeman accepted earlier that there had been that shift. And that's a useful summary. How you apply it in any particular case will be a matter for you in the first instance, Scottish ministers subsequently, but there have been refusals and there will be refusals. And in our submission, that's an indication of a balanced approach. There still will be cases of refusal, still will be cases of grant, but there has been a ratcheting up or an increase in support, and nothing Highland Council have said and should be taken to suggest otherwise. But we do say that that needs to be properly balanced and reflected. It's not a free-for-all, as no suggestion there is, but it's not a free-for-all. There's still a balance to be found in every case. So that's all I wish to say by response to Mr. Innes's canter through some of the other decisions. No doubt we'll both deal with this in closing submissions, but hopefully that makes Highland Council's position clear. The next matter he turned to was the issue of localised impacts, and he referred to the hearing statement, the applicant's hearing statement from yesterday at 2.3.5 to 2.3.12. And first of all, can I make it clear that in our submission there is no broad acceptance of 10 kilometres as being localised, but it would need to spend far too long than this morning going through each decision to make that good. That's something I'll cover in our closing submissions, just to highlight. And to take as an example, Kirkham, it's suggested at 2.3.5 that Scottish ministers did not form a specific conclusion on whether the effects were localised. Well, the reporter clearly did, and the reporter's conclusions were accepted by Scottish ministers. So I use that as an example of where one has to be careful about what is said in that hearing statement. And Mr. Innes kindly took you to it, but it's CD 8.3. And if I could take you back to paragraph 69.
With me, I'll make sure I have the correct one open. I'll go back to the master sheet and open it again. So we're going to
the supplementary report in Kirkham.
Yeah, which paragraph? Sorry.
69. It's on electronic page 12 of 18.
Okay, I have that.
You'll see what reporter there suggested in the beginning in the fourth line towards the end. In my view, a localised effect would be an effect that was rather less in its extent than might be expected for such a development. Now, that was a view that apparently Scottish ministers have upheld. He went on to say it wasn't localised in that case, and you see that over the page. Other reporters have reached the decision that it localised would be broadly equivalent to what one might expect from a development. In our submission, it is a matter of judgment in each case, which is not just about distance, but is about overall impact, and what may be localised for a wind farm on top of a hill, so to speak, may be a different concept than what may be localised in, for instance, this wind farm, which is on a much flatter location. There's a matter of judgment, which frankly reporters aren't given any particular assistance. I don't think by any of the decisions so far, or certainly not on the guidance. Just one minor point to pick up. I'm not entirely sure that Mr. Innes has it entirely correct about the Highland Council's position on redesign. Certainly my understanding was that if 4 turbines had been reduced, there would have been mitigation and a lesser impact. but you are considering the scheme that is before you, which is the full scheme, not one minus 4 turbines. So that's probably just a nuance between us. That's all I wish to say about localized effect. Our evidence, say for this, our evidence is that in this location, and for the reasons that were outlined primarily yesterday and rehearsed in part this morning, this by Mr. Whelan, this is not a wind farm that is restricted to localized effects. Having said that, in order to try and assist you, I accept Mr. Innes's point that simply because the effects are more than localized doesn't automatically lead to a refusal. There's still a balancing exercise to be undertaken, but I think I would say it's a pointer to refusal, but it's a factor. So that's all I want to say about his second aspect of his submissions. The third aspect was much briefer and was relating to the habitat management plan, and he sought to draw a contrast with the other cases. I'm simply going to say I'm not in a position to respond to that at the moment. I'll try and deal with that in closing submissions, but I would be surprised in every case, and I'm fairly certain it was the case in Clash and Darrick, that a significant weight was placed by applicants on their habitat management plans in all those cases. There may be an SSSI in this case, the level of difference that I will consider and deal with in closing submissions. But would say that I think in many of the cases it's a question of whether the habitat management plan goes to the extent to which it goes beyond mitigation for the impacts on peat that will undoubtedly occur and is a proper benefit, and that's a matter of detail. So that hopefully reasonably briefly, those should set out Highland Council submissions on those 3 aspects of that Mr. Innes drew attention to.
Okay.
Unless I don't see anyone else dying to say anything in the room, so I think those are our submissions on that at the moment.
Okay, thank you. So that's been useful, and yeah, all of the documents that have been referenced and will be referenced in closing submissions and your case summaries will be taken fully into consideration. Can I just check? I don't have video. Oh yeah, there you go. Just checking that you are still there. So we're going to move on to item 4. I think that we should be able to get through this agenda before lunch. So unless anybody is particularly ravenous, I'd suggest that we press on with this item. And so we'll move on to the Highland-wide local development plan as a material consideration. And as I said in my introductions, I'm going to open in this section with the views from the council, and then I'll go across to the applicant for counter views. And the first point for discussion there is the extent to which the most relevant policies and supplementary guidance align with FPF4. Mr. Whelan.
So I can.
Or Mr. Finlay.
Incompatibility is arguably more of an issue of it's crossover between issue of law and judgment. I was going to take you to 2, again, trying to deal with it reasonably succinctly, take you to 2 decisions. First of all, back to the supplementary report in Kirkham.
Which number was this one?
That's 8.3.
Okay, yeah, that's the one that's open.
And just let me get to my. Mr. Seaton deals with it at paragraphs 79 and 80, which is page 14, electronic page 14 of 18.
Yes, I have that.
And I won't read out those paragraphs, but broadly what he suggested was that there was no necessarily incompatibility, but if you were, the way you could test compatibility was that if you got a different result from applying the policy 67, which is the overarching Highland Council policy, and policy 11, in the MPF4, which everyone's agreed is the overarching wind energy policy in MPF4. If you've got a different result, they would be incompatible, which is looking at it from one end of the telescope, so to speak, and is a certainly a logical way to look at it. In our submission, you wouldn't get a different result in this case, and he doesn't. But I think all that one can take from that is that they're not necessarily incompatible, but they might be from his decision, and Scottish ministers endorse that approach as well. There is a more, there are two decisions, other decisions, which I just note but not turn to. A Canny, which is CD 86, there was no report, there was no inquiry. It was a case that Highland Council didn't object, and not surprisingly, and that was another case where Highland Council was satisfied that the application complied with policy 67 and ministers didn't form a view one way or other as to incompatibility, but there was no suggestion of incompatibility in their decision letter. And Meal Buey, which is a reporter's decision, which is 823, where the reporter did find apparent inconsistency, which we made it clear in our hearing statement we disagree with. In order not to just repeat our positions, what I propose to do now is to take you to, last point in this, is to take you to Sanker 2 decision, which is CD 819. And let me just try and get to that. And it's the reporter there deals with compatibility of LDPs with MPF4 in his supplementary report, which is electronic page 227 of 239, paragraph 274.
Yeah.
And I'm going to, in due course, I invite you to adopt this. This is a reasoned approach. 274, he sets out there's a need to give consideration to it. 276, he refers to the Planning Act provisions about incompatibility. Sorry, 275. 276, he makes the point that it is an Electricity Act and there's no primacy in decision making, and he doesn't have to make definitive findings on compatibility, which may sound like an easy way out, but and again, this is an example. Scottish ministers have accepted his reasoning here as well. So I'm not going to suggest that to you. It says where there are inconsistencies and incompatibilities, it is logical in the spirit of what is intended to give greater weight to MPF4. And that's perhaps an answer to your second bullet point, and is perhaps an obvious answer to your second bullet point in your agenda. He then, if you then go over the page, he sets out the various parties' positions, and in that case, he was dealing with a different policy IN2, which, a bit like the Highland-wide local development plan, was brought forward in a different situation where there was a spatial framework, and he deals with spatial framework in 281, where he says policy IN2 can be applied without reliance on the spatial framework, so that potential inconsistency is straightforward to circumvent. And I would say that's the same in this case. Policy 67 and indeed the supplementary guidance can be so applied. Generally, I tend to agree with the Council that policy IN2 identifies similar considerations to those which appear in MPF policy 11. And again, I'd suggest that similar here. The list of considerations in policy 67 is very similar to the list of considerations in MPF policy 11F, I think it is, or it's E or F. And he finds the LDP's approach in 282 to be support for wind farm to be more passive and restrained than the approach of NPF4. And I accept that as a general approach, that could be said of the Highland-wide local development plan. It's still a supportive policy, but it is perhaps more passive and restrained. He goes on to say NPF4 is a more proactive tone and more explicitly accepting of benefits, reading short. All told, he reaches his conclusion is that he's not identified any particular incompatibilities between NPF4 and the LDP of relevance to his case beyond the relatively minor differences as outlined. And he suggests that the differences are more related to emphasis and weight. And he returns to that point, he says in chapter 4 of his conclusions, and they're to be found on page 236 of 239. And there's nothing in particular that I wish to direct your attention to there. But in our submission, that is a logical and realistic approach to inconsistency, to the topic of inconsistency. Just because NPF4 is expressed differently or phrased differently, gives more express weight to one thing than the other, doesn't mean that the underlying LDP is incompatible. So whichever approach you adopt, whether it's that of Mr. Seaton and Kirkham looking at it, see if there would be a different result, or this slightly more nuanced approach, in our submission, there is no necessary incompatibility between policy 67 and NPF4. And that's, but if there is, and you find there is, then just to rephrase your second bullet point, the local development plan or the development plan, if there is incompatibility, NPF4 clearly has precedence. And even if there's not incompatibility, it's a question of difference of weight, a more nuanced approach, NPF4 has greater weight. So those are our submissions on item 4.
Thank you. Thank you very much. And I'll turn to the applicant. The one thing I did want to just question just before we do go to the applicant actually is the sensitivity study, which I believe this was adopted as supplementary guidance. So it does form part of the plan, adoption. So could you just give me your views on that's role and significance as well in the decision-making process?
Well, I hope I get this right, and if not, Mr. Williams will tell me otherwise, but I believe sensitivity studies are still relevant, and the AWPS makes that point. So it is still part of the development plan. There's clearly part of the sensitivity study that relates to the spatial framework, and I've sought to deal with that part in my submissions already. It's possible to read and apply the sensitivity study, bearing in mind the spatial framework no longer exists. Likewise, the other parts of the supplementary guidance, some are still relevant, some won't be. The sensitivity study was a joint production between Nature Scott and the council, and the judgments in there are capable of being applied. But insofar as there is a you have to read the sensitivity study in the light of the new NPF4. But it is still part of the development plan and is, we say, still capable of being applied if applied appropriately in the current circumstances of NPF4.
And now I'll go across to the applicant for their details.
Thank you. I wonder where coming back to that point initially anyway, just on the landscape sensitivity studies and just the wording in CD 509, which is the onshore wind policy statement. And you know, it very much is the case that have some relevance and continued relevance, but that is for a very specific purpose, really, and that is in terms of identifying sensitivity. It's not really to identify capacity. It confirms that they're a tool to help guide development to less sensitive locations, and they can inform a landscape and visual impact assessment. It's not really taken away from the need really to do that assessment. I think that is the critical bit, is to identify the sensitivities. I think that is the limit really that the OWPS is setting out. It's not really for any other purpose, and that they shouldn't really be used in isolation to determine acceptability of a development type in landscape terms, and doesn't replace that need for the individual LVIAs and assessments for individual proposals. So I think it's understanding that as a tool to inform those assessments, but it's really then the assessments to undertake and come to conclusions. That's my interpretation of it.
Before we move on there, then, is there anything that the council would like to add to that one, or are we okay to move on with the rest of?
We can move on with the rest. Just to say that I don't think we have taken it in isolation, but you know, that's. I think we're at one as to how it should be can be applied. But, yes, the group will be in the evening.
One further matter I wanted to raise in relation to the supplementary guidance. Obviously, it's in two parts. First is the onshore wind supplementary guidance, which in itself has at section 4 key development plan considerations, and it talks about important features and siting and design. I do want to highlight the age of this document in the sense that this is from November 2016, and the guidance that reflects. For example, it refers at paragraph 4.8 to SNH guidance for siting and design wind farms in 2014, and in fact, that's all been superseded by 2017. So the first point to note is that the key development plan considerations of siting and design of wind turbines actually references the old SNH guidance as opposed to the current guidance. And furthermore, it encompasses considerations which are from the SPP are no longer relevant. So to the same extent, so that the fundamental point here is that in that supplemental guidance, the key development plan considerations are actually seem to be driven by the SPP, and that I think is an important factor in considering whether it's incompatible, but also the second point is the weight which should be attached to it, even if it's not incompatible. I think I agree with Mr. Findlay that there's two points to be raised here. First of all, is it forms part of an overall development plan, and we are under section 36, so it doesn't have the same status as a planning appeal. One is trying to work out the weighting that should be attached to it. It does reflect a prior position. And respect of the landscape, what is described as a landscape sensitivity appraisal, which is document 704, does actually go well beyond just a sensitivity analysis, and is actually a capacity study to the extent that it is advising what might and might not be capable of being developed as opposed to mere sensitivities. And in that context, the detailed relative sensitivity is different from saying this is how it has to be. And we heard this morning from Mr. Whelan, he didn't think it was consistent, or the development wasn't consistent with the appraisal. That's not the purpose of relative sensitivity. It's to advise on relative sensitivity, not to be used in the way in which it was presented this morning. And the second point arising from that is that effectively, if I go to CT3 North Caithness, the issue is that since the publication of this guidance, Slickley is approved. That's a scheme that, as we've seen, has been successful in the auction and CFD auction this year, and will therefore be developed. And that changes the detailed considerations here, because effectively the guidance in capacity terms was consolidating and improving Stroopster. And so the context for considering this application is different already, because things have moved on and changed. And I think that is another relevant consideration. I just highlight, because we've got this morning evidence on this matter that was presented in a way of non-compliance with this. I just wanted to highlight that I will be referencing in the closing submission Nature Scott's submissions on this application, which are document 002-002, which is their consultation response to the 4th of March. Within the landscape section of that, it identifies that effectively the proposed wind farm, this is 2.4, lies in the north of Caithness, in the area of Sweeping Moorland and flows landscape character type identified by Highland Council have limited capacity for further wind energy development. So it's very clear that Nature Scott view the work that's been produced here as a capacity study, not just relative sensitivities. And that's how they viewed it. And I think it's particularly important that we were led to believe today about the large and open scale. Well, in terms of that being suitable for wind farm developments, Scottish Natural Heritage state the proposal relates reasonably well to the character, scale and landform of this large scale, gently undulating and modified surroundings. And that's also partially reflected in the fact that the Council's own capacity study identified limited scope for larger turbines. Now, that in itself is identifying that the area, the landscape character type, has some intrinsic capacity to accommodate wind farm development. And it's interesting to note that, counter to what the Council have just said earlier this morning, that in respect of this matter, Nature Scott said, in our view, the effects are limited in extent and severity due to the large scale and extensively modified landscape context. So we've got, in that terms of debate, this is a matter that has been reviewed by Nature Scott. They view it as a capacity study. They've passed their comments in relation to the intrinsic suitability of the site and the effects. And they've also gone on to say that as far as they're concerned, the proposal performs reasonably well to their own guidance, which is obviously the 2017, but noting that that is not what, but less so with the Highland Council landscape capacity guidance. So it's showing that conflict between the national design guidance and effectively this local design guidance, and viewing it of according and not according. That's not a relative sensitivity, that's a capacity study approach, which the onshore wind policy statement says is no longer the right approach for trying to find the right sites for onshore wind. So I just wanted to make that point clear about these particular documents, because I think they are important relative to what has been said earlier this morning, and I said I was going to come back on them, and I have done, because I think you've got to look at the whole context of this and how they're considered by other people. So they have been considered by other people, got their views, and to a measure, it's quite helpful to have bodies such as Nature Scott's version of how they view these documents and how they consider they're applied, and also how their view, and they've produced their own judgments for the Scottish ministers relative to this application in terms of their consultation response. Moving on, I'm going to hand back, having diverted the main point. I think we wanted to go back and actually discuss the actual LDP policies. I'm going to hand back to Mrs. Russell now. Thanks.
So I will, after you've finished, I'll move back to the council. So if there is anything that's been said or what is wanted to be said regarding what was just said, that's fine. Just to point out, I do say in there that it's the policies and the supplementary guidance is at the point. So yeah, I did fully expect the sensitivity study to be included as part of the decision, the discussion. So apologies if that wasn't clear. Mrs. Russell.
Thank you. So I think looking at it in that systematic way, I think it's helpful perhaps to first look at where it is incompatible, and that's been our view and within our evidence. First of all, it's looking at policy 61 in terms of landscape. Both the OWPS on onshore wind policy statement, which is reflected by MPF4, confirms that requirement that we've been emphasising today, the 2030 target, that recognition that it will change the landscape. I think we covered this point slightly there, but I think just to make the point, that the council is kind of taking into account the landscape capacity study as part of that policy. And for the reasons that we've just set out, we don't think that that is a appropriate in this case, because there needs to be that change, and that it has a different role, and that's just to inform the landscape and visual impact assessments that are undertaken. We're not saying, you know, as we set out, that they're not relevant. It's just that the purpose for why they're relevant, I think, is just coming to that point. And then going to policy 67, which deals directly really with renewable energy. I think the difficulty that we have really is that there's no balancing exercise which looks at the climate change targets. There's a little bit about renewable generation, but I think these are fundamental differences. And you know, it's that balancing requirement that's needed from NPF4. That policy requires no significant effect overall. And basically, if you don't meet that, then it doesn't meet the policy. And I just think that the way that the balance is set out is perhaps the wrong way around. As we talked earlier about how to apply policy 11, we're talking then about, you know, looking at how they've addressed impacts on landscape, and then within that consideration and putting that within the balance and looking at the contribution both to renewable energy generation targets, but also to greenhouse gas emission reduction. And I think that's where there's a key incompatibility with this policy, because they are seeking a different type of threshold, basically that it won't have significant effects overall. And whilst they acknowledge some of the renewable generation, they certainly don't with the climate change targets. I think potentially due to the age of when it was created. And it's for that reason I think that the Chief Planner's letter has set out what the transitional arrangements will be, that, you know, this is the new position, this is how we're going to reach those targets. And for that reason, the policies need to change, and we need to look at these more, the kind of more modern version of the renewable energy spatial strategy and how that is applied. I think that kind of covers that aspect of it. I think the other aspect of that policy is that there's no mention of the contribution or the benefits of co-location with battery and solar. It's very much, you know, looking at them individually, and you know, there are benefits that we rehearsed earlier on today, and we went through in quite a lot of detail about the benefits and synergy, the diversity to the system that creates, and I think that all adds to the benefit of the development. That's recognised in NPF4 in section in criteria A. So I think really, in summary, whilst NPF4 looks at the effects, both positive and negative, and weighs them with significant weight to the greenhouse gas and renewable energy targets, whether mitigation is applied, I think it also comes with further weight from policy 1 in terms of the tackling the climate crisis and nature crisis. I think that there is, you know, a conflict really with policy 67 in the thresholds that they set that need to be met. And ultimately, I think if you were to apply one and then the other, applying 67 and the supplementary guidance, you could come to one conclusion. Whereas if you were to apply NPF4 and taking into account the onshore wind policy statement, you could come to a different conclusion. And I think, you know, Mr. Finlay had kind of got to that point within the Kirkham decision. I think that is the test of whether something is incompatible or not. If you could reach a different conclusion on it, then I don't believe that they can be compatible. I think that is really the crux of what we're suggesting here today, that we don't consider it's compatible because you could be led to reach a different conclusion as to the different balancing exercises in the Council's policy and in NPF4.
Thank you very much. I've just got one matter I just want to address, and that is the significantly detrimental overall. That's a policy test that emerges really from policy 28 of the LDP on sustainable design, and it states developments which are judged to be significantly detrimental in terms of the above criteria and not accord with this LDP. In terms of policy 61, which is on landscape, it essentially doesn't really provide a development management test or an approach of what you should have regard to in formulating development. It says what should be taken into account. And then you get, as a footnote at the bottom of that policy, a reference to the principles and justification underpinning the Council's approach to sustainable developments are contained in the supplementary guidance Sustainable Design. The key principles outlined and underlying the guidance are set out in Policy 28 Sustainable Design. So in essence, in terms of the LTP, you can track this concept of significantly detrimental overall to be a policy threshold that they've used. And it then also comes into Policy 67 when it's significantly detrimental overall. So it is a policy threshold test. And in terms of the second point I want to make about 67 is if you then look at the tailpiece, which I think is often forgotten of the policy over the page, on page 124, it sets out an approach to onshore wind. And we see there that the onshore wind supplementary guidance will replace parts of the Highland Renewable Energy Strategy. HRES was a previous document that was council-wide and dealt with various aspects of renewable energy. And then it goes on to say it will identify areas to be afforded significant protection from wind farms, other areas with constraints and broad areas of search for wind farms. So you can see the underpinning of approach from the development plan policy and the subsequent development of the supplementary guidance being an approach which is one which is no longer supported in any way whatsoever by MPF4 or the onshore wind policy guidance. And effectively, it's an approach where the plan is going to control where everything goes and effectively steering proposals to particular locations and from constrained areas. It will set out criteria which will apply to consideration of proposals. It will seek information and certainty about applications considered by the council. So it goes way beyond just being a relative sensitivity and position. It's a whole regime that is predicated on the SPP approach. And in my submission, that is incompatible with the approach advocated in NPF4 and also the approach for the onshore wind policy statement, which is very clear on these matters. And so I just wanted to make those 2 points clear, because as I say, I think that very particular wording in 67 is sort of tracked through the LDP at heart. And if you're looking at 67, that's the threshold test that they apply, and it doesn't give the weighting that policy 11 does. So that there is that distinction. Now, you might say in a case such as a section 31, it doesn't really matter because you don't need to, on one view, reach an overall conclusion in relation to the development plan because this is a section 36 case, but you would need to do so if it was a planning case. But I think that slightly ducks the question of you have to construe the policy, and if by coincidence that the policies reach the same outcome, you can't just say that that's compatibility. Compatibility must be the formulation of the strategy and the purpose of the policy are consistent, and that's the challenge. I say is raised by the LDP policies in this instance, and particularly getting the right balance in the mix relative to the decision making. I was just going to raise one matter. In the agenda, you described the development plan as a material consideration. Just a word of caution that material consideration has a very particular meaning in planning, and that's why we've tended to use relevant consideration in section 36 cases, because it avoids any ambiguity that might be construed between a material consideration, which is a planning concept in its own right, and development plans. So as I say, we've tended to try and not use, well, I've been given advice from a certain senior counsel who is very, very strict on that and suggesting that we mustn't use material considerations because they've got such a very particular meaning in a planning sense. And that the relevant consideration is probably the better way of formulating it because it avoids that confusion. But that was the only other matter of clarification.
Habits must die hard for me. It's all the time with local plans and with planning considerations. I'll take note of that recommendation. Thank you. Is there anything that the council would like to come back with?
Well, first of all, I'd just like to endorse Mr. Ennis's deference to senior counsel. That's possibly the most forceful point he's made this morning or this afternoon. Just a couple from me, and then I will throw it over to Mr. Whelan. First of all, just coming back to the point that Lenfred made about the supplementary guidance being made on old SNH siting and design guidance. I've been at a number of inquiries where applicants have suggested there's very little difference between the two, and there's certainly in our submission no difference of substance in this case. The more important point that I wish to make is that when you're looking at incompatibility, in my submission, it's incumbent upon all decision makers not to reach a decision on incompatibility unless they're required to do so. There must be, if you can read the plans or the documents compatibly, and I refer back to the Sanker example I took before, by potentially ignoring parts that are clearly inconsistent, then that's the proper approach, rather than that which appeared to be being adopted by Mr. Ennis, which was to try and find a basis of incompatibility to rule out the plan as a whole. Those are the 2 points I wish to make. Mr. Whelan, do you want to add anything?
I think the point's been made. In terms of the way we've approached this application, the way we assess applications at the moment with NPF4 now in play, NPF4 is now part of the development plan. It takes precedence in terms of its policy content. How do you go into the detail of if you comply with policy 11 part E part 2 in terms of localised mitigation design of wind farms? You have to use the tools that you've got available to you. So you have to use the local plan policy, you have to use 67, and yes, the spatial strategy is gone and aspects in relation to wild land are gone. You can read the rest of the policy and it's entirely correct to do so when considering and assessing wind farm development proposals. In reading the criterion that's in the policy in Highland Wide, we do use the onshore wind SG. We use it to guide and to steer development proposals. We use to inform their decisions of how these designs can improve, where we want to see development, where we want to see more protection. The information then is contained within the spatial strategy. In terms of it's referred to as a capacity study. It's fair to say when it was originally undertaken, it does have information there about capacity, where we see additional capacity, where there is scope for more wind farm development and where there isn't. But the content goes, as you said, much wider than that. It goes into details of where the sensitive locations are, what's important to Highland, what's important, where are the gateway locations. All of that remains sound, and that information is then used to inform the applicant's landscape and visual assessment, which should then make improvements to designs and be used to tailor the design process. So when the application is made, it's the best it can be. I'm not convinced what you've heard yesterday that this is the best it can be for this area. And I think the approach being taken by the applicant is to say, well, NPF4 is now in play. Don't have any regard to the local development plan. Don't have any regard to the supplementary guidance or the content of the capacity study or the sensitivity study, I should say, because it doesn't suit their case. You have to see the relevant aspects of what's left in those documents and apply them. I think that's a point that the Sanker decision does really well. It strips out what's been effectively superseded and what remains. And until we have a new policy and a new ST, that's what we're going to have to deal with for the next foreseeable. So.
Thank you very much. I'm going to give the applicant one last chance on this item before we move on to item 5. If there's anything else you'd like to raise, the opportunity.
Yeah, well, I think the only response to this is that there's a very different position related to national policy. There's a sea change happened in the national policy, and that's reflected in the fact that we're now to look at relative sensitivities because we're trying to positively accommodate wind farm development, not find reasons to stop it. And in that respect, that fundamental change is really trying to say is where is there in general terms landscape sensitivities as opposed to trying to work out capacities. Because the difficulty with the minutiae of working through capacity studies of saying this will work here and this won't work here is that it flies in the face of the effectively the change in policy, which is to say that really we're considering weighing benefits and disbenefits against effectively the balance in policy 11. And if you circumvent that, that is not the intention of the onshore wind policy statement or MPF4 when properly construed. And that's the tension that is inherently there within the development plan as it stands in this area. Is that inherent tension of the micro statements as identified, stated, against the general consideration of what are the effects and how do they square in that balancing exercise. And that's the critical issue. So it's about identifying what effects are found and balancing it. And that's the decision making. That is the reflected. And that is how the ministers are approaching it. You are not finding them looking at the minutiae. They're actually even taking a step back from policy. They're just saying, what are the effects and how do they balance? And what we're seeing is that approach being adopted. And I think it's very fundamental in terms of the approach, in terms of the decision making. And you'll hear more on the closing submissions on these matters. So thank you.
Thank you. So before parties are given the opportunity to raise any other final relevant matters relating to planning and energy legislative context, I'd first like to invite any comments on the onshore wind sector deal for Scotland, which was published after the submission of hearing statements and was then lodged as a core document. So no obligation, of course, but if you'd like to provide any comments on this, that'd be appreciated. And I'll start with the applicant.
Yeah, thank you. Well, ultimately, I think it reflects the climate change and energy policy and the need for delivery of the renewable developments. A key purpose of it is how to speed up the decision-making process, and that just, I think, goes to the heart of what needs to happen to meet the targets and the challenge that presents. That delivery at a quicker pace for those targets. It also kind of sets out how the government and the sector are going to work together to resolve pinch points within the process and how collectively they can help to achieve the benefits. I touched on that a little bit earlier when we were talking about the benefits that we believe the applicant will bring alone. But there is strength in the sector and working with the Scottish Government to look at particularly to look at the links that the applicant has made in the local area and how others can potentially benefit from that as a wider sector, and looking at manufacturing and all the other benefits that the wider sector can kind of bring to Scotland as a nation, but also at a local level. And that extra strength that it can help to meet those NPF requirements in terms of maximising the benefits that come from the sector, Scotland nationally, but also right down to the local and community levels. It also kind of confirms about the efficiencies that need to be made in terms of grid connections and utilising investments in the area. There's potentially other investments coming from Slickley and from the Maygen tidal and how that connection can potentially best be utilised. And also that further support for making kind of efficient and sustainable use of those existing connections and infrastructure in the area. And then finally, in terms of just keeping the price down, I think that's the other recognition that it kind of seeks to bring. It's trying to make those efficiencies and having the best sites that you can have. With this, we're talking about the kind of co-location of solar and onshore and everything as well. I think they bring additional benefits to this onshore wind deal. It's not specifically there, but it was kind of recognised in the onshore wind policy statement. But that helps. They're all the measures that help to keep the price down, which is kind of recognised in the sector deal.
Yeah, I've got just one thing, sir. I mean, one of the points of the onshore wind policy statement is that we have a target date by which we have to have a minimum capacity built. That, as I said in the thing, is mission critical in terms of the overall strategy for Scotland. So onshore wind, as it currently stands, has this really important role to play in the time period to 2030. And that also is one of the reasons why effectively the sector deals in worked with the Scottish Government, is because so much is going to be happening over a relatively short period of time that it is worth the Scottish Government investing resources to work with the industry to maximise that economic benefit. And that is the sort of background and context. So it has that broad context. But at this local level, we've set out we have got a grid connection. It is very local. I think, again, in terms of our landscape evidence, we actually provided the actual location of it, which is very close to the site. And that's the shared grid connection with Slickley. That in itself, Mary Fisher set out the location of the joined up Gills Bay substation. So we've got an efficient connection that can be delivered in time to meet the 2030 targets. And that's effective and efficient local infrastructure. And the other thing about Slickley is that we've set out the contract for different round that was published this year. Slickley was successful, and it's broadly the same scale of development as this one, i.e. it's below the 150 metre threshold, whereby aviation lighting is required. But what it's proven to be is that technology located in this location can be effective in competing in the auction to win a contract for difference and have a contract to be brought forward through that mechanism. So what it does is it demonstrates our scheme is of a relatively similar scale to Slickley in terms of the turbine output. And again, it demonstrates that in all likelihood is going to be competitive in the future environment and helping to bring down prices. Because the CFD auction is the primary mechanism. You'll notice in our statements that it's the primary mechanism delivered by the UK government. In its white paper, it says we need to stimulate onshore wind and solar are critical. And one of the things that we're going to do is allow onshore wind to become part of the contracts for difference when they hadn't been in the past. And what we've seen in the last auction round, and particularly the one that we've lodged, is that actually it's onshore wind and solar utterly meeting that policy objective of being the technologies at this point in time that are delivering and winning those auction rounds. There was no offshore wind in it for this year. So again, it's demonstrating that consistency, and this development does fit with it because, as I say, we have the capability of sharing the grid infrastructure with Slickley. That is just a localized efficiency which minimizes the effect that substation is now going to be constructed, and it also has a benefit of making this project efficient as well. So in terms of that sector deal and the delivery of being able to compete effectively and deliver low cost energy, the local circumstances are aligning to make that efficient and work effectively as well. And I think that's just an additional point that is relevant, given we do have a target date of 2030.
Very much. And would the council like to offer any comments on the sector deal?
Yeah, I'll just keep it relatively brief. Effectively, it's an implementation document of how we're going to achieve our target by 2030. What needs to change in terms of the Scottish Government's decision-making process, in terms of speed of decision, and what needs to change at a planning authority level, and what needs to change in terms of industry, in terms of streamlining, making consistent applications, and comments about the implementation and the fast ability to implement this decision quickly if consented. I would stress that a lot's changing with the grid, and there was lots of discussion there about grid. We're looking at major redesign of our network to accommodate the offshore wind connection, so that'll be going into Spittal through the mainland down to Beauly across to Peterhead. Now, all of that infrastructure needs to be upgraded to accommodate the offshore wind farm market. By having an onshore solution as well as an offshore connection down to Peterhead for the offshore market allows more wind farm development to connect in. What it means specifically for this case, I can't tell you. What I can say is that whilst they might have a contract in place for a connection at this point in time, that network is continuously being changed. They don't appear to have a consent for any connection at this point in time. I wouldn't go any further than that, that I don't think it's material to the determination of the application. The ability to have a grid connection or not have a grid connection according to MPF4 isn't material. So looking back at the sector deal, what does it mean? The document is designed to bring more resources, more staffing, more training for local authorities as well. What that resource means on the ground, I'm not sure. And it also brings out the emphasis of how do we achieve this just transition if we're going to have all this onshore wind for our communities? What does that mean? The framework's not there, so we're still in the dark, but there's a programme in place and there's a series of commitments made by the Scottish Government of how that will be delivered. We touched upon some of the targets that have been issued in terms of how do we get to that 20 gigawatt target, and we're getting closer, And some of the solutions that set out within the document include things like the Eskilmuir, seismic array. If that solution was resolved, there's another 2.5 gigawatts. Therefore, we're even closer to reaching that if all of that is released and consented. So the urgency is stressed in the document, yes, but for every month that goes by and every decision that comes out and every wind farm that gets built, we are edging closer to that target. And I think we, as a local authority, we have to be selective over which schemes we want to see and where. We have in the region of 25 major applications or national wind farm developments in play at the moment. So I wouldn't quote 25, but either scoping, gate check, application stage, PLI, there's many options out there. So I'm just putting that across to you to say that this is one of multiple applications that will come forward and will help me in the 2030 target if all consented. And I think they don't all need to be consented. Yeah, I think the onshore sector deal document is helpful, but it doesn't move us any further forward, I think, in terms of decision making on the planning balance that needs to be undertaken in that exercise. Indeed, it just recognises that there is a balance still to be struck in terms of land use and making sure that if we have onshore wind development, that's not to the detriment of other land uses. So, the balancing exercise is clearly still to be undertaken. So I'll leave you with that.
Very much. Well, before we go on to the next item, I think, does Mr. Innes want to come back there?
Just one point. The council can't even concede that having the ability to connect the grid at the Gills Bay switching station is an advantage. MPF4 specifically says, in the case of proposals for grid infrastructure, consideration should be given to underground connections where possible. It clearly identifies the advantage of having a close grid connection with an underground cable has planning advantage. It removes the need to have overhead lines potentially traversing across the countryside. It's an efficient use of infrastructure. The lack of a grid is not a reason to refuse an application. Where you have a good connection and it is in close proximity, then it really is a major advantage in terms of avoiding ancillary effects and efficiency. And that was the fundamental point. It is an efficient use of resource for this to be located in such close proximity to the development in question. And we say combined to reduce the overall effects of development. And it's an efficiency point. It's an advantage to have that there. It wouldn't be that you would necessarily refuse, but it's clearly an advantage to have that grid connection. The wider issue about what may or may not be delivered, if you look at any of the Section 36 decisions to date, there is absolutely no debate about, let's see what happens. We might pick some good ones coming forward. There might be more coming forward.
It's okay at the moment. I think I take the positions, and yeah, I understand the position of parties. I've got this application before me to determine. I'll take into account the wider context as well, but I think that we've reached a point where there's obviously a difference of opinion, and I don't think it's going to help us to advance the case by exploring that further at this time. So I'd propose that we just ask the final before we go to the last item, is just to see whether or not there are any other relevant matters relating to the planning and energy policy context that we haven't already touched on, that isn't maybe, I mean, I've got your statements and whatnot here anyway, and we've already looked at elements of the statements where you flagged issues of concern or brought to my attention things within each of the statements. But just as a catch-all, I'll go to the applicant first and I'll ask if there's any other relevant matters that you can think of at the moment.
I think lunchtime's beckoning, so I think that's the lure of lunchtime avoids any further submission. But I think we've fairly canvassed everything we can possibly canvass this morning in terms of the main issues. I'm very happy with that we've covered them. Thank you, sir.
And from the council?
We're at one with the need for lunch.
Well, in terms of lunch, I can say it's up to yourselves. I really, in terms of the final, I think we've come to the end of this session. And basically, there is one other hearing session that we have to go through. But because all of the draft conditions have already been agreed, the content of, and none have been raised throughout the course of the two sessions we've had so far this week. The main thing we're going to be looking at in there is closing submissions, agreeing dates, and the actual submission of final statements and whatnot. I don't think it's going to take too long. Whether or not you want just a short break and then, I don't know if you have public transport to get or anything, or if you'd prefer to just have a full lunch and then come back to it.
Yeah,
we can do either.
I would think we're happy to go on now and finish that off. It's only going to take 5 minutes, I would have thought.
Yeah. So I mean, if we just close this hearing session on policy and legislative context, and we move through to the hearing session on draft conditions, just because this might sound a little artificial at this point, but just because this will be bookmarked and some people may be joining us at this point specifically to listen to this this session, I will give a quick introduction. So as you've all been here for our previous sessions, we won't revisit the housekeeping or the introductory remarks. For the benefit of those following along that line, my name's Stuart West. I'm a reporter appointed by ministers to consider this development proposal for renewable energy development comprising 10 turbines, associated solar array and battery, and other ancillary development on a site 8 kilometres to the southwest of John O'Groats. It's my responsibility to put together to consider all of the evidence and to put together a report with a recommendation for ministers' consideration. For the benefit of those following along at home, could I just ask the two parties to introduce yourselves, those that are going to be involved in this session? I'll start with the applicant.
Yes, good afternoon. So my name is Colin Innes. I'm a partner in the law firm of Shepherd and Wedderburn, and in terms of the situation, I don't know the extent to which we're actually going to end up discussing conditions, or if it's just going to be a discussion of the closing submissions. But if there's conditions to discuss, it'll be a combination of myself and Mrs. Russell. But if it's just closing submissions, it will just be me contributing. So that's us introduced.
And the council.
Yes, my name is James Finley, King's Counsel. As Mr. Innes has just indicated, if it's just closing submissions, it'll just be me. If not, then it is likely to be Claire Farmer McEwen and or Peter Whelan. Yes.
Thank you very much. So the applicant submitted an updated list of draft conditions in advance of this session, and as both parties have agreed to those conditions, item 2 allows parties to raise for discussion any additional conditions that have been identified as needing to be introduced or updated following the sessions that have taken place. As far as I'm aware, there aren't any additional conditions that parties would like to discuss. No. Okay, so we would move swiftly on to item 3. And as I advised during the pre-examination meeting, DPA is moving to a more streamlined form of reporting in order to expedite the process of issuing our recommendations to the Energy Consents Unit. To that end, we're moving away from the reporters summarising the position of parties based upon statements provided and whatnot, and doing that within the body of the report. We're moving away from that, and instead we're asking parties to prepare their own summary of case, which will either be attached as an appendix to the report in the format that it's provided, or it'll be linked within the report. Within item 8 of the pre-examination meeting, I'm not too sure if you have the note there, but it was agreed that this should be
Colin, can you hear me?
Yes.
I think I'm back. Apologies. Sorry about that. I think my connection timed out momentarily. Hopefully you can hear me again. Okay. I'd mentioned that we would be including a summary of case attached or linked within the report. Hopefully you heard that. And then within item 8 of the pre-examination meeting, it was agreed that this would be provided at the same time as or forming part of the closing submissions. Whilst we've not had any formal inquiry sessions, I would still welcome closing submissions from parties to sum up your cases with regards to the sessions that we've had over the past couple of days. At the pre-examination meeting, we stated that for the council, closing submissions and case summaries would be submitted 14 days after the final day of the hearings, and it'd be 28 days after for the applicant. However, as stated within the note of the pre-examination meeting, there is a degree of scope to adjust this timetable if parties don't feel it'll afford enough time to put everything together. So since the council's date is the closest, can I ask whether or not you think the 14 days is realistic and achievable, or would you like to suggest something as an alternative?
Yes, so I'm usually a fan of trying to do closing submissions as soon as possible, but I have another wind farm inquiry for Highland Council next week, Strathoical. So I would ask for an extension to 21 days for the council.
Okay, I think that that's reasonable, and it won't affect my own timetable for putting together my recommendation and writing up my report. To that end, would the applicant agree that if we're given 21 days from now for the council, that 5 weeks from now would be sufficient to give you an extra 2 weeks on top of the applicant?
Yes, I'm absolutely delighted with that. So, and the timetable seems sensible, and I understand why Mr. Finley wants an extra week, given what he's got to do next week.
Well, I'm more than happy to accommodate that. I would like to thank everybody for the time today and for us getting through things so efficiently, especially yesterday, where I don't think it's often that we get sessions, hearing or otherwise, on landscape and visual that can be concluded in a day. So I think that we did give everything full and thorough consideration, and it was a good presentation of evidence on both sides. So I'm confident that we took everything that we needed to. But I think that doing that so efficiently was down a lot to the work that both parties did in advance of the session. So again, I'd like to thank you for that. Now I'm going to take everything away. in the interim period before you submit your closing remarks, I have a lot of other information to be looking at. I may be doing another site visit based upon the information that I heard in yesterday's session, just to crystallise a couple of things in my own mind. It won't need to be accompanied. Again, it's just some transitory routes that I think would be beneficial for myself, without stopping at viewpoints in particular, just to advise you how that what the reasoning for that would be. And yeah, I'll fully take everything into consideration, and that includes the representations submitted by members of the public and other bodies which weren't subject to hearing sessions. Before I do close, I'll give parties a chance to say one last thing. So, Mr. Innes.
Yes, could I just say thank you very much for the way you conducted the hearings in terms of producing the agendas in advance. It has allowed us time to prepare and to probably help make it efficient. I would also like to thank the team at Highland Council. And one of the reasons why we selected hearings for this case was that we do have and have had really good dialogue with the officers. We may disagree on some matters, but I know there's been a lot of cooperation to get the paperwork in a place that's got maximum agreement. That does derive, and we know it takes time and effort to do so. But that is one of the reasons. So I would like to on behalf of the applicants, to thank the council team for their cooperation in the run-up, because it has made things easier. And no, it wasn't always easy, and I appreciate that's sometimes the case in terms of the volume of material that's put in. But as I say, we have done our very best to minimise the issues before you, and that derives from the hard work that's been put in by both our witnesses and I know the Highland Council team. So, as I say, I want to formally recognise that. Thank you.
Very much. Okay, so it is now 1:30 or thereabouts on the 18th of October, and I'm going to close this inquiry. Thank you very much for your time.
Thank you very much, sir.